Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission. We all signed in. To consider final and proposed rules under the Dodd-Frank Act. I'd like to welcome members of the public, market participants, and members of the media, as well as those listening to this meeting on the phone and watching the webcast. I would like to thank Commissioners Summers, Chilton, O'Malley, and Weegan for their significant contributions to the rule writing process. I also want to thank the CFTC's hardworking and dedicated staff. They're working day and night and many weekends. I was in here Saturday and I saw numerous folks, and I thank you on that. Today is our 21st open meeting to consider Dodd-Frank rules, and I'd particularly like to welcome Commissioner Weegan to his first open meeting. And I'm told somewhere there's a rule book or something that is the seat where the most junior commissioner sits, and so Commissioner O'Malley has now switched over there, and this is the seat where the most senior commissioner sits other than the chair. I don't know, but that's why you have us switched around here. So today we'll consider two final rules, the investment of customer funds and a rule with regard to the registration process for foreign boards of trade. We'll also consider one proposed rule, the process for designated contract markets and swap execution facilities to make a swap available to trade. Last Friday, the Commission approved an interpretation related to anti-fraud authority provided in the Dodd-Frank Act.
I'm not hearing anything at this time. I'm doing a test on the line right now, not hearing anything at this time.
There you have it. So maybe I start over. So that was not webcast? What do we do? I'm going to pause. Keep going? All right, we're good. Last Friday, the Commission approved an interpretation on Section 742. This related to retail commodity swaps, and this interpretation had originally been calendared for today, but we completed by seriatim last week, and it's also up on our website, or should be sometime today. The CFTC is working to complete Dodd-Frank rules thoughtfully, not against a clock. We've finished 18 rules and have a full schedule of public meetings this month and well into next year. And we've benefited from significant public input, including 25,000 comment letters, 1,100 meetings, 14 roundtables. I've also directed staff to host additional roundtables as well. After the first of the year, staff will put together a roundtable on mandatory clearing for swaps. Under this congressionally mandated process, the Commission has 90 days to review a clearinghouse's submission and determine whether a swap is required to be cleared based on various factors that are in statute. And though the clearinghouses will decide on the timing of the submission, this could be in the near term, and thus this staff roundtable will provide further helpful public input regarding the implementation of the clearing mandate. Today we are considering a rule to enhance customer protections regarding where clearing organizations and futures commission merchants can invest customer funds. We're losing the connection again here, but I'm going to keep going. I believe that this rule is critical for safeguarding of customer money. The Commodities Exchange Act in Section 4DA2, did I get that right, Phyllis? Prescribes that customer funds can only be placed in a set list of permitted investments. From 2000 to 2005, the Commission granted various exemptions to this list, loosening the rules for the investment of customer funds. These exemptions allowed futures commission merchants to invest customer funds in AAA-rated sovereign debt, as well as to lend customer money to another side of the firm through repurchase agreements. Today's rule prevents such in-house lending through repurchase agreements. I believe there is an inherent conflict of interest between parts of a firm doing these transactions, and I'm glad that we're able to consider a staff recommendation on a final rule today. The rule also would limit a Futures Commission merchant's ability to invest customer money in foreign sovereign debt. This is in part a result that Dodd-Frank in Sections 939A required that the CFTC remove all reliance on credit ratings from its regulations. And thus we can no longer just say if it's the highest rated or AAA backed debt. We proposed this rule in October 2010, and since then I've consistently felt that the CFTC needs to finalize this rule to ensure customer funds are best protected. This rule is important, but I might say the agency will look at additional ways to enhance customer protections. Among possibilities we're reviewing are the audits on Futures Commission merchants, Futures Commission merchants' monthly and daily reporting to regulators, how Futures Commission merchants are examined for compliance, the Futures Commission merchants' relationship with self-regulatory organizations, custodial arrangements, and possibly increasing the transparency between Futures Commission merchants to customers. In essence, what do they communicate to their customers, not to their regulators, but to their customers regarding how they invest those funds? As we've previously reported, along with the self-regulatory organizations, the CFTC is also doing a series of reviews of the segregation in Futures Commission merchants' accounts. In addition, the CFTC's 5 commissioners and staff will be working with the self-regulatory organizations and market participants on further enhancements and ideas to customer protection. The Commission is also looking soon to finish rules on segregation for cleared swaps. Segregation of funds is the core foundation of customer protection. Also today, the Commission will consider a final rule to implement the Dodd-Frank provision for registration of foreign boards of trade, which will make the swaps market more open and transparent. The registration system replaces the CFTC's current practice of staff issuing no action letters to foreign boards of trade, and it's the result of an amendment in the Dodd-Frank Act by Senators Feinstein and Senator Levin. I know there were many others that worked on it, but it's specific to those that registration regime. And I think that exchanges and trading platforms that allow investors and hedgers and speculators to meet in an open and competitive central market is fundamental to our markets and promotes competition. And even market participants who are either exempted or choose not to use a trading platform will benefit from transparent pricing and liquidity on trading venues. When markets are open and transparent, prices are more competitive, they're more efficient, and costs are lower to the companies and their customers. Transparency benefits, I think, all of us. Lastly, we'll consider a proposed rule for a process by which contract markets and SEFs make a swap available to trade. I've also directed staff to put together a roundtable to hear from the public on this topic during the comment period. This is something we've done from time to time. I think it's enormously helpful, particularly during comment periods. Before we hear from the staff on the rulemakings that we'll consider today, I will recognize my fellow commissioners for their opening statements. I think it's a great honor. I turn to Commissioner Summers.
Thank you, Mr. Chairman, and I too would like to welcome Commissioner Wiegand to his first CFTC Dodd-Frank open meeting. It's been a very fast-paced first 6 weeks for him, I know, but just want to say how much I appreciate the communication between his office and being able to work with you on all the rules before us today. So welcome. I also want to thank the teams that are before us today. As I always say, but really mean it, your hard work and the long hours you put in, and especially in the last few days before we're getting ready to consider these rules is much appreciated. Today we are considering the final rule creating a registration system for foreign boards of trade that make their products available to U.S. customers by providing them with direct access to their electronic trading system. This rule will replace the existing process of staff-issued no-action letters. The CFTC has a long history of recognizing regimes with comparable regulatory objectives. Currently, we have 20 foreign boards of trade operating under this no-action relief. It is very important for me that we retain the type of regulatory cooperation that we have with other jurisdictions. I believe that global markets benefit from international support and collaboration among supervisors. And it is my hope that under this new registration regime, the CFTC will continue to be a global leader in recognizing and granting access to foreign boards of trade with comprehensive and comparable oversight from their home country regulator. In September of this year, the Commission voted on a proposed compliance and implementation schedule for the clearing and trade execution requirements of Section 2H of the Act. I reluctantly supported the proposal because it provided some degree of certainty regarding implementation deadlines. I was discouraged, however, that the Commission had failed to provide any certainty with respect to what would trigger the trade execution requirement. I urged the Commission at our September meeting to define what it means to make a swap available to trade. The proposal before us today represents some progress in that direction. Unfortunately, I think we've taken a wrong turn. The proposal provides that DCMs and CEFs, rather than the Commission, will make the determination of when a swap has been made available to trade by considering 7 enumerated factors, or any other factor that the DCM or CEF may view as relevant. The DCM or CEF may base its determination on any combination of the factors or on one single factor. The rules provide that the DCM or CEF may either certify the determination or seek approval under the Commission's Part 40 rules. Although the Commission could theoretically overturn such a determination through its rule certification or approval review, the lack of any parameters on how these factors should be considered will make it very difficult, if not impossible, for the Commission to reverse a determination. Once a determination is final, all other DCMs and CEFs are obligated to determine whether they list or offer the same or economically equivalent swap, and if so, they must treat the swap or economically equivalent swap as having been made available to trade within the meaning of Section 2H8. And although the proposal is silent on the matter, all over-the-counter participants will also have to determine whether a swap they trade or would like to trade is the same or economically equivalent, because if the Commission has determined that the swap must be cleared, OTC trading must cease. This approach is deeply flawed, and I cannot support putting it out for comment, even recognizing that it's just a proposal. This proposal, if finalized, would allow a single DCM or CEF to bind the entire marketplace to a trade execution requirement through an ill-defined analysis that the Commission will be unable to reject unless it finds that the determination is inconsistent with the Act or Commission regulations. Given the lack of any mandatory objective criteria contained in the rules, it is difficult to envision how the Commission could find a made available for trading determination to be inconsistent with the Act or regulations. For example, the proposed rule would allow a DCM or CEF to declare a swap made available to trade based solely on a finding that there are ready, willing buyers and sellers. Will a swap that trades once or twice a year qualify under this test? Could the Commission find a determination based on 1 or 2 trades a year to be inconsistent with the rule? These are certainly questions that I have. The definition of economically equivalent set forth in the proposal is also problematic. It directs the DCMs and CEFs to determine whether a swap is economically equivalent with another swap after considering each swap's material pricing terms. I'm not sure what that means, and I expect that market participants will not be sure either. The proposal, in effect, would delegate implementation of the trade execution requirement of Section 2H8 of the Act to DCMs and CEFs. The fact that Congress did not explicitly direct the Commission to make the made available for trading determination does not mean that we should turn this critical responsibility over to DCMs and CEFs. I strongly disagree with the statement in the preamble to the proposed rule that this is a balanced approach. In my view, going down this path amounts to an abdication of our responsibility as a market regulator to provide clear rules of the road. We've given no legitimate reason for taking this approach, and I do not believe that Congress intended for us to allow a single DCM or CEF to make determinations that will have profound market-wide implications. Revisions to the list of permitted investments under Rule 1.25 is an issue that the Commission has been grappling with for quite some time, beginning with a survey conducted in 2007 to gather information on how Futures Commission merchants and derivatives clearing organizations were investing customer funds. In May of 2009, the Commission solicited comments through an advance notice of proposed rulemaking, and we issued a proposed rule in October of 2010. In July of this year, staff circulated to the Commission a proposed final rule. I supported most of the provisions contained in the July version of the rule, but believed some of the revisions need further vetting, primarily with regard to the issues surrounding the ban on in-house transactions. The preamble to the version of the rule we are voting on today clarifies that the scope of the ban and distinguishes in-house transactions from in-house sales of permitted investments and in-house exchanges of collateral to convert customer funds into collateral that will be accepted by a DCO or foreign board of trade as margin. I support the ban on in-house transactions with this clarification and also support the harmonization of Rule 30.7 with the investment limitations of Rule 1.25 and the concentration limits on various investments to promote portfolio diversification. I have lingering questions, however, regarding the investment in foreign sovereign debt. A number of different recommendations on this issue have been presented to the Commission in recent days. The version before us today bans investment in foreign sovereign debt, but invites FCMs and DCOs that seek to invest customer funds in foreign sovereign debt to petition the Commission for exemptive relief pursuant to Section 4C of the Act. I believe that investment in foreign sovereign debt, to the extent that an FCM or DCO has balances in segregated accounts denominated in that country's currency, should be permitted to hedge foreign currency fluctuation risks so long as the foreign sovereign debt qualifies under the overarching objectives of preserving principal and maintaining liquidity. I question the process of including in the that is included in the rule, and I have a number of questions on how this will be handled under 4C. I would like to close with an observation on the dearth of information we have regarding how FCMs and DCOs are actually investing customer funds. The cost-benefit analysis states that FCMs currently hold over $170 billion in segregated customer funds and $40 billion in Rule 30.7 funds. Throughout the cost-benefit analysis, we acknowledge that the new restrictions on investment may cause some forced sales or administrative costs to convert unacceptable investments into permitted investments. But we have no way of calculating these costs because we're not in a position to know the composition of customer fund portfolios. We should know. The last time the Commission attempted to collect this information was in 2007. As the last 4 years have demonstrated, we are living in volatile times. Financial instruments that are safe today can quickly devolve into risky propositions. The Commission should make a concerted effort through either a reporting regime or regular surveys to collect information on the investment of customer funds on at least a yearly basis. We should also think about ways to regularly review and update the list of permitted investments under Rule 1.25. Thank you, and I look forward to the questions for the teams.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks, Mr. Chairman. I also want to welcome Commissioner Weegan, who I'm very impressed with so far. Mark, you've been helpful to me and others already. And I also want to thank Commissioner Summers for taking on some added responsibilities lately. It's been helpful not just to me and the other commissioners, but I think helpful to the country, although everybody may not realize it. So thank you for being so tireless and working hard on those other issues, Jill. We get emails all the time from folks and we get phone calls, and I can tell you that lately they haven't been so pleasant. And people are concerned in general about customer money with regard to one of the cases we're involved in. People are concerned that we don't quite get it, that the regulatory world hasn't necessarily shifted enough yet after the passage of Dodd-Frank. It's all these important rules that have not yet been put in place. And quite frankly, a lot of them just think there's a big disconnect. There's a disconnect between the average folks out there and what goes on in Wall Street, and what goes on in Washington. And, I think you see it down at McPherson Square and other places, that they just don't think we get it. There's a disconnect. And sometimes I think they're right, that we don't get it all the time. Other times it's just a matter of explaining what we're doing and, ensure them that we're from the government and we're not part of the problem. So this is an effort to continue the good work that we do, and we'll just have to do the best we can to explain to people what our job is, what our responsibilities are. And the first responsibility is to protect customer funds. Priority for us. It's got to be up there, that we need to ensure that those funds are sacrosanct. And today we're going to take one action, I hope, with the 1.25 reg, banning internal repos. But there are also other things that we need to do. One, and I've talked about this a lot in the last month, we need to do regular and robust deep data dives. And that is going beyond just the sheet that says this is where the segregated funds are, and actually looking to the bank accounts to make sure the money's there. And not just at COB, but it's there intraday, that it's there all the time. The second thing we need to do is ensure that the penalties that we impose, which are defined by statute, and Commissioner Weejan and I have talked about this ad nauseum, that the penalties may not be the appropriate deterrent to using customer funds in a potentially nefarious way. And I think we'll have a little bit of conversation on that when we get to 1.25. But look, by law, it's a $140,000 penalty if somebody, and I'm not speaking about any individual case, if somebody can transfer hundreds of millions of dollars overnight and potentially make some money off that, is a $140,000 penalty a deterrent? Of course not. We'll talk about that. And the last thing is something that's out of our purview, but it's within our interest. And that is something that exists in the banking world and something that exists in the securities world. And that's an insurance fund for futures customers. Sort of a belt and suspenders approach. If we don't locate all of the funds from a given circumstance where a firm may go into insolvency or where they may be in bankruptcy, there could be a gap between what customers put in and what they will receive. But if there's an insurance fund, that is something that could make them whole, make the customers whole. I hope Congress will consider it. Again, it exists in the securities world, it exists in the banking world, and I think it's time that we have one in the futures world. With that belt and suspenders approach, if our oversight, surveillance, or enforcement arm breaks, if that belt breaks, people won't lose their pants. Thank you.
Commissioner O'Malley, you still go after Commissioner Chilton. It didn't change.
No.
Thank you, Commissioner Chilton.
And it is the tough act to follow. Commissioner Chilton does an excellent job every speech he gives. And I'd also like to welcome Commissioner Weejan as well. I'm your buffer, so it's a lot easier to follow me than it is Commissioner Chilton. I, too, am impressed with Commissioner Weejan's rapid adoption of these issues and uptake. It's an extraordinary time with a massive amount of work, and he's done a very careful job and thorough job, and I've been very impressed with all the work he's committed thus far. And keep that seat warm over there, and it's a absolute place of power, so enjoy it. Today we have before us two final rules and a further notice of proposed rulemaking. I greatly appreciate the cooperation of the staff in accommodating many of the requests I have made for changes in these rules to make them a better product. It is that time of year when I start to fill out my Christmas list. And this year I've come with some new requests, and I'm going to ask for some old things. But the chairman also preempted two of the items with certain roundtables, so it's Christmas come early. Last Christmas, my first wish for the commission was to take the opportunity to organize the rulemaking process in a manner that would build a derivative regulation from a strong foundation, as opposed to the regulatory jumble of our earliest attempts to put out the 50-plus Dodd-Frank rules. I'm pleased that Congress has taken notice and retained language in the Commission's annual appropriation bill directing the Commission to develop and publish a 60-day comment period, a schedule for implementation and sequencing of all rules and regulations under the Dodd-Frank Act, under specifically Title VII. Not only will it help U.S. markets, but a desire for such a schedule was a common refrain from fellow regulators in Asia, which I just returned from, who are attempting to coordinate their rules with both U.S. and European reform efforts. My second wish is that the Commission continue its early efforts to organize itself around technology. We need to upgrade our 20th century surveillance tools to oversee a 21st century electronic marketplace. Congress has provided a significant increase in funding for technology. It would be a missed opportunity if the Commission does not capitalize on this targeted investment to focus on developing a strategic plan for technology. My next Christmas request was for the Commission to schedule roundtables and to provide the market participants an opportunity to fully vet their concerns with staff before they are in a sea of uncertainty between effective dates and implementation dates. Based on the Chairman's statements, Christmas has come early on two of the three roundtables I am seeking, and I appreciate the Chairman's willingness to hold these two meetings on mandatory clearing and trading, which are, I believe, very closely linked. And both of these rules are sufficiently vague, as Commissioner Summers pointed out, about the definitions and what the determining factors are. As many will recall, I sent out a letter on the mandatory clearing requirement, and we received a number of very good, thorough responses back, which are on my website, and I think will help inform the staff roundtable. So I greatly appreciate your willingness to do that, and I know there's strong support among the Commission. But there's one more roundtable that I'd like to reiterate my request for, and that's on clearing and documentation. Since the Commission has approved a proposal to ban the FIA ISDA Clear Derivatives Execution Agreement, particularly the tri-party agreement, market participants from all sectors have continued to discuss the best technological solutions for executing swap transactions. I support the development of a technological solution that will minimize the chance that an intermediary or DCO would reject a swap for credit reasons. However, market participants do differ on how fast the swap markets can evolve to implement this new technology. They also differ on where the technology should be most effectively deployed. Namely, the debate seems to be deploying it at either the intermediary, the execution platform, at the DCO, or a new concept that was new to I was recently informed of, a centralized credit hub. Thus far, the Commission's proposal will ban the tri-party annex, but does nothing to provide the critical technology solution that the swaps market desperately needs. Our next step should be to schedule a roundtable and discuss the most effective solutions available. Wow, I cut out a bunch of my speech here, which is probably a great relief to many. Getting back to today's final rules, I'd like to thank Bella Rosenberg, Dwayne Andreessen, and John DeBorg and their teams for their work on these rulemakings. On the Foreign Board of Trades, I intend to support the final rule on registration of foreign boards of trade. The rule sets forth a new requirement that links the approval of an FBOT with a clearing organization. I have two primary concerns with this rule, however. First, does this rule provide adequate clarity regarding the new requirement that links FBOT approval to a Commission determination regarding its clearing organization? This is a new standard which is tied to my second concern. The rule relies on international principles and standards that are currently, but may not be in the future, comparable to our own standards. I've just returned from a trip to Asia where I met international regulators. Uniformly, the first question that they asked me was, what standard will the U.S. apply in permitting mutual recognition for clearing, for regulation of clearing organizations? Foreign regulators are concerned that the U.S. would demand that U.S. clearing organizations and their regulators comport with standards that are not strictly that are not necessarily under the principles set forth in the Bank of International Standards Committee on Payment and Settlement Systems and the Technical Committee under IOSCO. And I'm looking forward to hearing some clarification from the staff on this point. With regard to the investment of customer funds rulemaking, I intend to support the final rule on investment of customer funds. As recent events have highlighted, the protection and preservation of customer funds is fundamental to our markets. By limiting investments of customer funds to a subset of instruments that currently have minimal risk, this final rule is a step towards enhancing customer protection. However, as I have emphasized in a statement on MF Global, the Commission must not be complacent. It must take additional action to bolster public confidence in our customer protection regime, including enhancing transparency into risks that our intermediaries assume. I hope that the Commission can develop a notice of proposed rulemaking in the near future to improve transparency into intermediaries and on behalf of their customers. I am pleased that this rule before us today, however, permits greater utilization of money market funds, which would enable intermediaries and DCOs to more easily diversify investment of customer funds. Further, I'm pleased the rule restricts investments in two failed government-sponsored enterprises that remain eligible entirely as a result of federal backstop protection. My support of the final rule on investment protection is not without reservation. With regard to sovereign debt limitations, I am reminded of my recent discussions in Asia with regulators and market participants. Both participants in Singapore and Australia had exposure to MF Global and are fighting to secure lost customer funds like U.S. market participants. The fact highlighted the interconnection of our economies and markets. I recognize that foreign sovereign debt can no longer be considered a riskless investment. But the truth of the matter is we are all a global economy together. The coordinated efforts by the Federal Reserve and 5 other central banks last week evidence this truth. I'm pleased that the final rule states that the market participants may petition for an exemption, that the Commission would consider such exemption on a case-by-case basis. While the rule provides no standards for acceptable holdings, even those hedging currency exposure or operational risk, I hope that the Commission will act in a timely manner to clarify the acceptable practices and debt holdings to minimize disruption to the market. Finally, I intend to support the proposed rulemaking on making swaps available to trade. My main purpose is to focus the public commentary on the mandatory trading requirement. Pursuant to this proposed rulemaking, an execution platform would determine that a swap is, quote, available to trade, end quote, after considering a minimum of 8 liquidity factors. The execution platform would then notify the Commission of its determination either by requesting a rule approval or by certifying the rule. My concern with this proposal is that the Commission is fostering an inherent conflict of interest that could negatively impact the swaps market. The proposal is permitting those who have the greatest financial incentive to force all trading onto a platform to determine which swaps should be executed. Fearing this exact situation, many of the buy side have already urged the Commission to play a more active role in the mandatory clearing requirement. For example, the American Benefits Council stated the Commission and not platforms with pecuniary interest should determine whether the swaps have been made available for trading. They further stated that the Commission should base its determination on empirical data of swap liquidity. I recognize this issue is not easy, particularly due to the linkage between mandatory trading and the mandatory clearing determination, unless, of course, the Commission applies the lowest standard of simply listing a product as sufficient. As mentioned above, I believe the Commission should engage the market through a roundtable, which the Chairman has agreed, and I'm thankful. The Dodd-Frank Act has placed the Commission in a position to preside over a significant portion of the sweeping financial regulatory reforms. Although we often attach a numerical label to mark our progress in terms of proposed and final rules issued, pages published, and the comments received, it all comes down to making sure that we ultimately create a regulatory structure that will promote the successful transformation of the over-the-counter markets to decrease systemic risk and increase stability. We must make sure we get it done right, not just done quickly. I hope the Commission will focus the rulemaking schedule as requested by Congress and conduct the roundtables so we will benefit from the market input. Thank the staff again for their hard work and their thoughtfulness in developing these rules. Thank you.
Thank you, Commissioner Amalia. And before I turn it over, I just want to make sure Macy's going to do well in Christmas time as well. I look out for her, because she and I are kind of aligned on this stuff now.
I did ask about her Christmas list. It is not yet ready, so we will have to see what she comes up with.
Okay. I mean, if Macy needs any help from me,
Macy does not need any help from anybody. Macy is quite sufficient to get what she wants when she wants it.
All right, I'm good. I'm glad about that. Macy's is one of his young ones. Thank you, Commissioner Malia. Commissioner Weegan, we welcome you to the dais. It is wonderful to have you here and all the input that you've given already in these 6 weeks.
Thank you, Chairman Gensler. And thanks to the rest of the commissioners on the dais for their kind comments this morning. I really appreciate that. Before I comment on the rules before the Commission today, I want to thank Chairman Gensler and Commissioners Chilton, Summers, and Amalia for their graciousness during my first weeks here at the Commission. You've been both welcoming and extremely helpful during my transition here, and I've sincerely enjoyed working with each of you, especially on the rules we are considering today. I also want to thank the professional staff for their assistance. I look forward to knowing all of you better as we work together to meet the important mission of this agency. I also have been meeting with members of the public almost nonstop since I arrived. I want to express my special appreciation to those who have reached out to offer suggestions and comments to these rules. Public input is an indispensable part of the Commission's rulemaking process, as well as the best safeguard against unintended consequences. So your involvement was critical to ensuring that we have the best version of the rules before us. I want to stress my belief that the Commission should remain open to course correction as the facts change. The Commissioners and staff have been active in responding to questions and issues raised by my office and others. I believe the rules under consideration today are better for it, and I believe we must remain open and nimble during the implementation phase. I will be supporting all 3 rules today, though I intend to pay especially close attention to the Commission's final rule concerning the protection of customer funds. Today we are considering changes to Regulation 1.25, and it's being done against the backdrop of recent developments in the FCM community. It's important to note that the current investigation underway here at the Commission will yield additional facts to explain what led to the disappearance of customer funds. But the Commission cannot ignore the widely known fact that thousands of futures customers do not know where their money is. Futures customers generally, and indeed the public, are rightly demanding that the Commission take immediate steps. These steps are intended to reassure the public that we are doing everything we can to safeguard customer money. Although we cannot be sure the present rule will address every issue ultimately raised by the recent FCM failure, it is an important step towards reemphasizing the Commission's commitment to ensuring that customer money is invested in a manner that preserves principal and maintains liquidity. I believe this rule is necessary to restore confidence that this is the case. It is incumbent upon the Commission, however, to revisit Rule 1.25 and our other rules as markets evolve, circumstances change, and new information is brought to light. An investment once viewed as safe may not be viewed as such only a few months later, and vice versa. What is deemed a prudent investment cannot be a static determination. Toward this end, we remind market participants in this rule that the Commission can and should implement further changes to our rules whenever it is presented with an informed basis for doing so. There are a few issues important to protecting customer funds that the Commission was unable to address in this rule, but perhaps should address in the future in order to restore confidence in the futures markets. First, I agree with Commissioner Chilton that misconduct with respect to seg funds must be addressed immediately and with all appropriate sanctions. The Commission therefore should consider whether its current approach to penalties in this area is a sufficient deterrent to misusing or misplacing customer funds. Second, the Commission should review how examinations at FCMs are conducted and evaluate our compliance regime to ensure that customer funds in segregated accounts are fully protected. I support the Chairman's request for a review of the Commission's regulations in this regard. Finally, I also believe the staff should begin thinking about an appropriate FCM disclosure regime that would disclose to customers certain risk and investment information concerning the firms that take custody of margin. Customers have a right to know how FCMs and DCOs are investing segregated funds, and they are doing so prudently. And that they are doing so prudently. I hope the Commission can take this matter up in the near future. Today, I'll also support the staff's recommendations with respect to the registration of foreign boards of trade, offering direct market access to participants located in the United States. Congress granted the Commission new authority to register such foreign exchanges in the Dodd-Frank Act, and I believe that the final regulations appropriately implement this new authority. The regulations provide a standardized and transparent process that will benefit the public. They also provide a firmer legal foundation than the current no-action regime governing access to FBOT trading platforms by U.S. participants. In my view, the final regulations better ensure the fair treatment of applicants through formal and published processes and criteria. They also align our registration regime with a number of countries that permit U.S. exchanges to provide direct market access internationally. Finally, I am supporting the Commission's renotice of an issue from the CEF and DCM proposals in order to seek further comment on the meaning of the phrase made available to trade, or MAT. There has been some confusion concerning the Commission's CEF proposal and its provisions relating to MAT assessments and reports. I support the staff's recommendation to reconsider and clarify our initial approach and to propose a new MAT determination process with greater Commission involvement. Again, I think it is important that we permit course correction as new facts come to the Commission's attention, and I am confident that the proposal will elicit useful comments that will inform our ultimate approach. I look forward to reading the comment letters and reviewing our options for meeting our congressional mandate while ensuring that U.S. swap markets remain liquid and efficient. And I also wanted to add my support for Commissioner Amalia's request for roundtables on both this issue and the mandatory clearing requirement. That's something he and I discussed this week. Again, I want to thank the staff for all their hard work on each of these rulemakings. I also look forward to the Commission's future efforts to implement the Dodd-Frank Act in the weeks and months ahead. Thank you.
Thank you, Commissioner Wiegand. And I think roundtables, I'm going to just make two comments before I turn over. I think roundtables are very helpful. Of course, you have to be respectful of staff just getting the wealth of information prepared before a roundtable and then to be, make them worthwhile while they're still doing the ongoing business of overseeing the futures market, the business of completing our rules, and so it's just a matter of, so on the third and possibly fourth, fifth, and sixth roundtable that people have ideas for, it's mostly just how staff reacts and whether they can, I'm supportive of as many roundtables as can work and be balanced into their schedule. I also do note, though, two commissioners just maybe didn't put it on the list, but I want to thank Commissioner Wiegand and Commissioner Malia because I share your view that I think that one of the areas to enhance the confidence in the SAG system is for customers to know where their money is and what it's invested in. And I noted Commissioner Malia and Commissioner Wiegand put that in, and that's in one of the lists that I've asked staff to really think about what recommendations we could have. It would probably require rule changes, but to really to be open to get the staff to bring forward recommendations in that area, as well as the examination and audit area and custody and any areas that any of you think appropriate. Please weigh in directly with staff. So, with that, I think we're going to turn over to four people who have been here before. The staff will make presentations concerning their recommendations on the final rules as well as the proposed rule. After each presentation, the floor will be open for questions, and following the discussions, the Commission will take votes on the recommendations presented. To that end, I ask unanimous consent that all final votes conducted in this public meeting of this Commission be recorded votes, and that the results of those votes be included in the relevant Federal Register release. Without objection, so ordered. At this time, I'd like to welcome John DeBoard, Phyllis Dietz, and Nada Radhakrishnan. of the Division of Clearing and Risk, and Ward Griffin of the Office of the General Counsel. A nice bow tie today, Ward. There's a long history of Ward and his bow ties. Mark.
Mr. Chairman, I second that.
All right. We could have a vote now on your bow tie. To present their recommendations on the final role and investment of customer funds. I turn it over.
Thank you. Before we turn over to the presentation on Regulation 1.25, I would like to highlight a couple of points, which I know the Commission is aware, but members of the public may not be aware. The first point is that the statute limits the investment of customer funds. I'm going to read from the statute. Section 4DA2 says that such money, meaning customer money, may be invested in obligations of the United States, in general obligations of any state or of any political subdivision thereof, and in obligations fully guaranteed as to principal and interest by the United States. So it's essentially U.S. Treasuries, what we call municipal securities, and any other obligations fully guaranteed as to principal and interest by the United States. And Congress repeated this provision in the declared swaps provision when Congress passed Dodd-Frank. And in fact, Congress did not change this when Congress had an opportunity to do so when it was considering the Dodd-Frank Act. So Regulation 1.25, to the extent that it permits investments in anything else, is allowed because the Commission exercised its exemptive power under Section 4C of the Commodity Exchange Act. And as Commissioner Wiegand pointed out, it's the overarching principle or thought is that the FCM and the DCO must make such investments to preserve principal and maintain the liquidity of the investments. So I think it's important to bear this in mind, certainly for the members of the public who may not be aware of the provisions of the Act and the interaction between the Act and Regulation 1.25. So I'm going to turn it now over to the team. John DeBoard, who has been the attorney, has been working on this substantially. Phyllis Dietz, who is the resident expert on Regulation 1.25. And Ward Griffin from OGC has been very helpful in this effort. Thank you.
Thank you. Good morning. I'm John DeBoard, Special Counsel for the Division of Clearing and Risk. I'm pleased to present for your consideration our recommendation for final regulations regarding the investment of customer funds in secured amounts. Under Section 4D of the Commodity Exchange Act, customer segregated funds may be invested in obligations of the United States and obligations fully guaranteed as the principal and interest of the United States by the United States, and general obligations of any state or any political subdivision thereof. Starting in 2000 and again in 2004 and 2005, pursuant to authority under Section 4C of the Act, the Commission substantially expanded the list of permitted investments to allow investment in GSEs, CDs, commercial paper, corporate notes or bonds, general obligations of a sovereign nation, interest in money market mutual funds, and in-house transactions. Other rules dealt with repurchase agreements, standards for investing in instruments with embedded derivatives, and requirements for adjustable rate securities. In connection with that expansion, the Commission included several provisions intended to control exposure to credit, liquidity, and market risks. For example, requirements that the investments satisfy specified rating standards and concentration limits and be readily marketable and subject to prompt liquidation. The Commission has been and continues to be mindful that customer segregated funds must be invested in a manner that minimizes their exposure to credit, liquidity, and market risks, both to preserve their availability to customers and DCOs and to enable investments to be quickly converted to cash at a predictable value in order to avoid systemic risk. Toward these ends, Regulation 1.25 establishes a general prudential standard by requiring that all permitted investments be consistent with the objectives of preserving principal and maintaining liquidity. In October of 2010, the Commission approved a notice of proposed rulemaking proposing that the Commission amend its regulations regarding the investment of customer segregated funds. Certain amendments reflect the implementation of new statutory provisions enacted under Title IX of the Dodd-Frank Wall Street Reform and Consumer Protection Act. Other amendments addressed certain changes to the list of permitted investments, notably the elimination of foreign sovereign debt and in-house transactions, a clarification of the liquidity requirement, the removal of ratings requirements, and expansion of concentration limits, including asset-based, issuer-based, and counterparty concentration restrictions. They also address revisions to the acknowledgement letter requirement for investments in money market mutual funds, revisions to the list of exceptions to the next day redemption requirement for money market mutual funds, the elimination of repurchase and reverse repurchase agreements with affiliates, the application of 1.25 investment limitations to 30.7 funds, the removal of ratings requirements for depositories of 30.7 funds, the elimination of the option to designated depository for 30.7 funds, and certain technical changes. Today, DCR recommends that the Commission adopt the proposals in the NPRM as proposed, except for the following areas. In the fall of 2010, the Commission had proposed to limit the GSE asset class to only U.S. agency obligations that are fully guaranteed as to principal and interest by the United States. Today, DCR recommends that the Commission retain the current permissibility standards for GSEs with the caveat that investment in Fannie Mae and Freddie Mac remain permissible only so long as these entities are operating under the conservatorship or receivership of the FHFA. In the fall, for money market mutual funds, the Commission had proposed a 10% asset-based concentration limit and a 2% family of funds issuer-based concentration limit. Today, we recommend that FCMs and DCOs be allowed to invest all segregated funds subject to other concentration limits in money market mutual funds with at least $1 billion in assets and with a management company of at least $25 billion in money fund assets under management. FCMs and DCOs would be allowed to invest up to 10% of segregated funds in money funds with less than $1 billion in assets and or a management company with less than $25 billion in money fund assets under management. Non-Treasury only funds would be subject to a 50% asset-based concentration limit, and non-Treasury only funds would also be subject to a 25% family of funds issuer-based limitation, as well as a 10% individual fund issuer-based limitation. Finally, in the fall, we had proposed a 5% counterparty concentration limit for repurchase agreements. Today, DCR recommends increasing that to a 25% counterparty concentration limit. That concludes a summary of our recommendation. I'd be happy to answer any questions. Thank you.
Thank you, John and Ananda. The Chair will now entertain a motion to accept the staff recommendations concerning the final rule on investment in customer funds.
So moved.
Second.
Thank you. I'll now open the floor to allow commissioners to ask questions. I support this rule for the reasons I stated earlier, and I'll have a little statement to go in the Federal Register. So I don't really have questions on this, but John, I just wanted to clarify, maybe it's for the public listening, though a lot of people have called this Regulation 1.25, this also covers something called Regulation 30.7, is that correct?
That's correct.
And the reason I think that's important is, but let me clarify, 30.7 is about, well, in your own words, what customer funds does that cover?
30.7 is an account class. If I have an FCM, you're my customer, and you tell me that you want to invest in foreign futures, I have to put that money in the 30.7 account. I cannot put it in the customer segregated account. So it's money supporting foreign futures.
So importantly, this covers both monies customers put up for domestic futures.
Correct.
And that's what's called 1.25.
No, that's 1.25 applies to all the three account types. One is the cleared futures account, cleared futures and cleared options and futures. The second is the cleared swaps account, which Congress created last year. And the third is the foreign futures account. So 1.25 applies to the investment of customer funds by an FCM or a DCO in all three account types.
And then Rule 30.7 would also be amended to be in conformity.
Actually, we're not amending 30.7. We're just saying that if you are an FCM and you have customer money that supports positions in foreign futures, you must follow 1.25.
Oh, I see. Technically, it's done in 1.25,
Correct.
but it covers the
Correct.
30.7 funds.
Correct.
Is that, or maybe your colleagues
Know
have
what we're
something?
doing?
Yeah, I believe there is a modification to the language of 30.7. Yeah. It's at the very end.
I'm sorry. It says you must, I beg your pardon, it's the other way around. It says you must invest it in accordance with 1.25.
Right. So there is
It's a cross-reference.
there's a cross-reference, but the important thing for the public is this covers not only your funds that are put up for domestic futures and swaps, but also if you put it up through a futures commission merchant, regulated and registered with us, to send it into what's called a 30.7 account.
Correct.
All right. Thank you. Again, I support this rule. I think it's really important and critical that we have such protections, and I'm pleased that we could get to this point. Commissioner Summers.
Thank you, Mr. Chairman. I have a couple of questions, and the first part of my questions are with regard to the foreign sovereign debt. I support the rule before us today, narrowing the scope of investment choices. However, I have a lot of questions with regard to why we would seek to eliminate investment in foreign sovereign debt in the rule, yet entertain further exemptions from FCMs or DCOs that seek that type of investment. So I guess my first question would be how we're going to determine under 4C that it's within the public interest to exempt foreign sovereign debt if we felt that in the rule we should eliminate the investment.
I think that's a great question. I think we would ask the petitioner to explain to us why it's in the public interest. So I can see how, they may say, well, I get a lot of balances in a particular foreign currency, therefore I should be allowed to invest in that foreign sovereign debt. In which case, I think it's entirely appropriate for the staff to ask, why do you need to invest? Is it because you have to post margin in that sovereign debt form, in which case it's not an investment, it's a transformation of cash for collateral. But the way I look at it right now is the burden's on the petitioner to explain to the Commission why they believe an investment in a particular sovereign debt is in the public interest.
I guess I would expect, because within the comment period, I guess we received 13 comment letters that commented on the investment in foreign sovereign debt, and 12 out of the 13 of the letters suggested that we retain foreign sovereign debt as a permissible investment in some varying degree. So I would guess that we're going to have people who will immediately petition us for this type of exemptive relief. So as an example, the CME announced today that they will accept Chinese currency as collateral for trading in all of its products beginning in January of 2012.
Right.
How will we make a determination that it's in the public interest to allow CME to invest in Chinese sovereign debt under our 4C analysis?
So I think what this, I haven't read the release in whole, Commissioner, but I think what they said, they will accept RMB as collateral, which means that they will expect people to give RMB to them. I'm not sure whether it's limited to a particular contract. I need to take a look at that. But that's not an investment. That is a DCO saying, I will accept this as collateral. The way I look upon an investment is you've got something, you've got cash, and you invest it in something else to get a return. Not because you've got to post that other form of collateral up with another DCO or another FCM. So I make the distinction there. So I guess, if a petitioner says, we'd like to invest, say, for example, RMB cash in, I'm assuming the Chinese government issues bonds, although I do not know that for a fact. The question we will ask is why? Why do you want to do that? Why do you think, tell us how you think that preserves principle and maintains liquidity. And tell us why you think that is in the public interest. Because the key about Section 4D and 1.25 is that the term investment. It's an investment of what the customer gives you in something else.
And would you envision that this process will be such that you will make individual determinations with regard to individual?
I think that's possible. It depends on what the FCMs and DCOs want to do. I'm not sure what. I can anticipate getting a petition very soon. I just don't know what forms of which particular sovereign debt people would like to invest in. The other issue is how they demonstrate to us that a particular sovereign debt is creditworthy. As the Commission is aware, in our rule, we cannot make references to credit rating agencies. However, I think it's a pipe dream to assume that nobody makes a reference to credit rating agencies at all. People still do. And that's how sovereign debt is issued. Sovereign debt is rated right now. So we'll have to see whether in our 4C process we can consider rating agency ratings. I think the statute, correct me if I'm wrong, Ward, just says we cannot make reference to it in our regulation. I don't know whether it prohibits us from considering it at all.
That's correct. Section 939A of Dodd-Frank mandated that all agencies review the regulations and remove any reference to or requirement of reliance on credit rating. So that does, in fact, just apply to the regulations.
So, and we'll probably ask questions about liquidity, evidence of liquidity.
And how often do we anticipate we would review any of these exemptions under 4C to know how will we deal with fluctuations in the risk associated with anything we're granting exemptions for?
I think that can be answered in one of two ways. One is it's entirely appropriate, I think, for the Commission to place restrictions on, if the Commission were minded to grant the petition, to grant restrictions, and to provide for the petitioners to provide information to the affirmative obligation to provide information to the Commission about things like you talked about, Commissioner Summers, the liquidity and the creditworthiness of a particular instrument. For example, staff has been observing the yield spreads between some sovereign debt against a AAA index. And we've observed that the yield in Italian and Portuguese and Irish debt has improved. Now this, we're doing it because, we've got staff looking at it every day, but I think it may be entirely appropriate for the recipient of such relief to have an obligation to tell the Commission, either on a daily basis or on a weekly and monthly basis.
Okay, thank you. The second issue that I had a couple of questions on is with regard to the money market mutual funds and the concentration limits that we impose on other instruments are lower than the concentration limits that we have on money market mutual funds. And my question would be, if we're allowing indirect investment of up to 50% and through money market mutual funds in certain instruments that have lower concentration limits through direct investment in those instruments, do we believe that money market mutual funds are somehow safer than direct investments in those other instruments?
It's a reflection of some of the adjustments made by the SEC to 2A7. Essentially, the staff felt that through money market mutual funds, it's sort of an independent way to ensure high quality securities, short maturity limits, and so forth. So we're aware of that difference, but that's the reason for the treatment.
And then, will our rules in this area be consistent with the SEC rules?
How do you mean?
Well, you said that the reason why we decided to allow this is because of the SEC changes.
So money market mutual funds are regulated by the SEC under 2A7, and 2A7 is what dictates what the money market mutual funds are allowed to invest in, the quality of the securities, maturity limitations, and so forth. And so in our rules, we refer to 2A7.
Because they've upgraded their rules,
Yes.
we feel more comfortable.
Yes. The one distinction is that I think under 2A7, money market mutual fund has up to 7 days to redeem. And we've said if you want to participate in, if a fund wants to be 1.25 compliant, it must provide for, is it next day liquidation? Yes. Yeah, next day liquidation.
Thank you.
Yeah, I would just add that the next day redemption requirement is not new in this regulation.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks, Mr. Chairman. I support the rule and thank staff for the good job you've done. I did have some questions. I think I'm going to need some other people, though, so we're going to have to do a little bit of musical chairs. If I could get David Meister, our Director of the Division of Enforcement, and we already have Mr. Berkovitz, our counsel. So I'm talking theoretically now, first of all, for my questions, and this is for Mr. Berkovitz, Mr. Meister, and Ananda. If you'd like to answer, feel free also. So 3 division directors. And so I'm talking theoretically, and I understand at the outset that everything I'm talking about would depend upon the facts and circumstances with regard to an individual case. So by law, there is a fine for the misuse of customer funds of $140,000. If I say anything, correct me. Raise your finger, and I'll let you correct me. So it's a $140,000 penalty. So, in theory, you could have an FCM that transferred millions, hundreds of millions of dollars, and the penalty is $140,000, which doesn't seem like much of a deterrent to me. So my question is, how do we define what the actual violation would be? Again, depending upon the individual facts and circumstances, and I'm not talking about any individual case. For example, Mr. Meister, if there was, say, $100 million that was transferred from customer money and it went to 3 different places, so it's a transfer out, but it goes to 3 different places. Would that be 1 violation or 3 violations?
Just sort of taking your qualification that obviously a penalty depends upon facts and circumstances. Let me just address one premise. The Commission can impose, generally speaking, the Commission can impose a penalty of $140,000 per violation of the Act or a rule, or, and that would be a maximum penalty, or 3 times the gain to the defendant per violation. So there's actually 2 alternatives. Our penalties are not based upon the amount of a loss, however. In your hypothetical, I would say that it really does depend upon a number of things, including perhaps conduct of the defendant, which might give rise to more than 1 violation. The number of victims involved might give rise to more than 1 violation. It might. The duration might give rise to more than 1 violation. So, and again, generally speaking, we in the Division of Division of Enforcement and the Commission considers a whole host of factors in determining the number of violations in play that would give rise to the maximum possible penalty.
So it is theoretically possible, given the facts and circumstances of the individual case, that such a violation could be 3 different violations and not just 1. Theoretically possible.
Absolutely.
Okay, and the same would go, I assume, but correct me if I'm in error, that if during the day you transferred 3 different times to the same place, that even though it was on 1 day, that given the specific facts and circumstances, that it could be 3 violations, even though it occurred on the same day. Is that also correct?
Again, sure, that is theoretically possible. for us to recommend.
Now, I want to talk about this other criteria that you mentioned, the amount of money that they would make. So if you're an FCM and you say, look, it's only a $140,000 penalty, so I'm going to take $100 million and I'm going to use it to make some bet overnight. And with $100 million, I mean, I could make millions and millions. And the fine's only $140,000, so that's not a deterrent. But you say that there's also this treble damage, essentially. You're saying it could be 3 times. Is it 3 times the 140 if they made a profit? Say they made a profit of $10 million. Is the damage 3 times the 140? Is that what we could theoretically, given the facts and circumstances, fine someone? Fine an FCM?
Again, we're talking about civil monetary penalties, which is actually something different from damages. But so this is civil monetary penalties, and in your hypothetical, one way to calculate the civil monetary penalty maximum would be 3 times the gain to the defendant.
3 times the gain. So if they made $10 million, they could the civil monetary penalty could be $30 million. Is that correct?
Theoretically correct.
Everybody hear that? So $30 million on a $10 million gain if you use the customer money illegally. 3 times the gain. Mr. Berkovitz, is there anything else that we should be looking at? If we, and I do, I can't speak for my colleagues, want to be as tough as we possibly can as a deterrent to misusing customer funds, is there anything you'd add to what this discussion Mr. Meister and I had here today?
One thing I would note, Commissioner Chilton, and again, it depends on the hypothetical, but I think some of your hypotheticals and the questions that you posed had possibly would indicate potentially a deliberate intent to take these funds and use it for some other purpose. If there were a certain level of intent, I'd just also add there are criminal provisions in the Commodity Exchange Act. There's one specifically, Section 9A1, is a criminal provision for knowingly embezzling, stealing, or criminal intent to convert customer funds that have been deposited to margin or guarantee. So there's that specific criminal provision. Secondly, there's the more general criminal provision regarding willful violations of the Act in general, knowing of the unlawfulness and a willful. So potentially, I think some of the hypotheticals that you pose could raise criminal issues as well.
Actually, I had one follow-up question. Thanks, Commissioner Chilton. In the hypothetical that Commissioner Chilton laid out, where you had theoretically 3 violations, I'm kind of curious, if you had a gain of $10 million to the defendant, and the statute allows you to choose that as a basis for the penalty, so you can treble that, you still have 2 separate violations. Would it be? How does the statute read? Do you have to? Is it one or the other, or could you do treble damage on one violation, and then just for good measure, do 130 for the other 2, for each of the other 2?
I guess the way the statute is written is per violation. The penalty is imposed per violation. I don't, as I'm sitting here right now, I don't know of a restriction such that you would have to calculate the penalty for one violation in a course of conduct one way, and then keep to that calculation for each of the violations. So, again, just sitting here, I would imagine you could calculate the maximum penalty for one of those violations one way under one theory, and then the maximum penalty for a second violation under an alternative theory. In other words, just to put that more directly, so $140,000 maximum for one of the violations and triple the gain for a second violation.
Thank you.
Okay. Thank you. And well, the point I'm trying to make is that from my perspective, look, if you are out there and you've violated the law, you've misused customer funds, then don't expect me to give you a third of what you should get. If you violated, for example, and again, not talking about any specific matter. This would depend upon the circumstances of the individual case. But if you went out and for a year you messed up and used customer funds illegally, that you should be fined $140,000 every day, or, depending upon what the profits is, 3 times that amount. I just want to be clear that I'm done with any settlements or deals that would lessen that amount. There are people out there who've lost their money. They're having, as I said earlier, using their college kids' funds. They're using their retirements because they've lost their money. And we've got to do everything we can. I don't know if there's more we can do. It's something the chairman and I have talked about a little bit, whether or not there's more we can do. But we've got to provide a real deterrent out there. And I think $140,000, when you could spend millions of dollars, hundreds of millions of dollars on a bet, just silly. Just silly. That's all I have. Thank you.
Thank you, Commissioner Chilton, and a cameo from Commissioner Wiegand. Commissioner Amalia.
Thank you. I'd like to ask one question before I follow up to Commissioner Chilton. Commissioner Chilton seemed to indicate that there was one account that the money came from. If this money was moved from an FCM to some other entity, wouldn't we do the $140 million violation per account of the accounts it came from, or is it because it's an omnibus account that would only be a single?
Again, there are a number of ways in which the Commission can and has determined the number of violations. I would think it would be relevant to that assessment as to the number of accounts in play. The Commission has issued some authority with respect to this. I should add that the Commission has also issued a policy statement on how it does calculate penalties. That was from November of 1994, which is on the books and people can consider, and it's something that we in the division consider. There are a number of different factors that go into play, and it's something that the Commission always does consider as well.
Well, thank you, Commissioner Malia. I mean, I just wonder, which maybe my colleagues are, 1994, should maybe we look at updating that? Is that something that could be done internally to make a recommendation to the Commission as whether or not we should reevaluate that? I'm not sure about the process.
The 1994 policy statement that I'm talking about is a Commission policy statement concerning the factors it considers in determining the amount of the sanction. I'll point out, however, that also says that the Commission is not limited by those factors, but it does list them. I imagine that the Commission could issue
so the types of things we're talking about, if we wanted to up that, it's a Commission document, so it requires 3 of us to make that. Is that correct? Well, to the extent that staff can come up with a recommendation for whether or not we should update that 1994 document, I'd appreciate hearing what you have to say.
Right. Just so it's clear, Commissioner Chilton, that doesn't talk to the $140,000 or triple the gain. It just talks about those are the things that set maximums. What it does is it lists a number of factors that the Commission does consider in deciding where between 0 and the maximum it wants to impose.
It's talking about the exact questions the 3 of us were just asking about if it's one account or if it's 3. I mean, it could get into those types of things.
Yes.
And provide some guidance to people that we wouldn't be limited to, but we could use, depending upon the facts and circumstances.
Yes, correct.
I have no further questions about this hypothetical or theoretical, so if you're welcome to stay at the table if you want, but I would like to thank the team for rationalizing its analysis of the risk posed by certain instruments and adjusting asset-based and issuer-based concentration limits. Nowhere is this rationalization more clear in the final rule treatment of investment securities of government-sponsored enterprise and money market funds. Since the public does not have the benefit of having the rule in front of them, I'd just like to go through some of the differences between the final rule and the proposed rule for their benefit. First, with respect to GSE securities, the proposal would have would have effectively banned investment of customer funds in such securities, correct, in GSEs?
That's correct.
Including securities that have performed well during the financial crisis, such as the Farm Credit System GSE and Federal Home Bank?
Correct.
And now, how does the final rule treat investments of customer funds in these securities?
Well, they'd be retained. The only change between the current permissibility standards in which those investments are allowed and what we're recommending today is simply a caveat that for just Fannie Mae and Freddie Mac that those investments would be allowed only so long as they're operating under the conservatorship or receivership of the FHFA. But the Federal Home Loan and Farm Credit you mentioned would be permitted.
And what of the how will we treat the potential replacement entities to Fannie and Freddie if those reforms are undertaken?
Any limited life follow-ups to Fannie and Freddie wouldn't be permitted. Would not be
permitted. All right. Second, with regard to money market mutual funds, the proposal would have limited investments to such funds to 10% and investments in a particular fund to 2%. Correct?
That's correct.
And the treatment of customer funds in those in the final rule would do what?
Well, it's a bit more of a nuanced approach. We make distinctions between size and also fund type. So I'm going to read from my notes just so I'm clear
Please.
on it. FCMs and DCOs can invest all their segregated funds in money market mutual funds with at least $1 billion in assets and a management company of at least $25 billion in assets under management. FCMs and DCOs can invest up to 10% of segregated funds in money funds with less than $1 billion in assets and or a management company with less than $25 billion in money fund assets under management. So that's the size treatment. In addition, non-treasury only funds, so typically we mean prime money funds, would be subject to a 50% asset-based concentration limit. They'd also be subject to issuer-based concentration limits, 25% for a family of funds and 10% for an individual fund.
Thank you. Let me turn to the foreign sovereign debt issue. It is an understatement to say the safety of certain foreign sovereign debt has been in the news recently. I'd like to explore some of the nuances and frankly build on some of the questioning from Commissioner Summers about sovereign debt, this investment versus transformation debate that I'm still a little confused about it, so I'd like to ask a couple of questions. On its website, LCH indicates that in addition to the U.S. dollars and euros, it accepts cash collateral in the form of sterling, Canadian dollars, Swiss francs, Japanese yen, Swedish krona, Danish krona, and Norwegian kroner. Let's assume that for the certain contract, LCH only accepts cash collateral in Canadian dollars. Let's also assume that the U.S. customer would like to take a position in that contract. Now that we've banned Canadian debt, how would an intermediary hedge foreign currency exposure that it faces on behalf of a customer?
So the question is, LCH says I will only take CAN dollars?
It currently does today.
Okay. So the customer's got a choice. He can deposit CAN dollars. FCM passes it on. If the customer gives something else, let's say CAN bonds, FCM sells the CAN bonds, gets CAN dollars, passes it on. Customer gives treasuries, FCM sells treasuries, get U.S. dollars, buy CAN dollars with the U.S. dollars, buy the debt with CAN dollars. It's not impossible. They can do it. Yeah, it's you know, in some of the comment letters, with all due respect to the commenters, I don't think they're being completely honest with all the steps. It involves a couple of steps, but it's not impossible. And if financial institutions with the sophistication of these FCMs tell me that it's impossible, I'd like to know why.
Okay. Do we have any sense of what the cost of these alternative hedging arrangements might be?
Again, I don't know whether there's any. I don't understand when these firms say there's hedging risk, because you hedge because you have a risk. It's not clear to me. What I don't understand is the customer gives me Canadian dollars, and I'm not obliged to pass it on. I have Canadian dollars. The risk belongs to the customer, not to me. So I don't quite understand where, when the FCM says I got a risk, I don't quite understand what the risk is. Because the point is, it's customers' money.
I do have some frustration. I would note that on the cost-benefit analysis that we noted that this is a $100 million significant, major, what do we call it, a major rule. Therefore, it has an impact of over $100 million in economic impact due to the change that we've implemented. We don't do a very good job of quantifying those costs in the rule, but if the analysis, as the memo says, that we have $170 billion in segregated funds and $40 billion in Part 30 funds, it doesn't take much in terms of changes to go over $100 million. Less than 1/10 of 1%, I think, is what the memo says. So, yet none of that quantitative analysis is reflected in the rule. I would just continue to make my concerns raised regarding our economic analysis and what goes into it and how we come up with these numbers, because I can't tell what the costs are actually in the document as a result of this. And maybe you could explain why that is and why we don't have a good quantitative analysis, and maybe it's the point that Commissioner Summers raised earlier, that we don't really know what they're holding.
That's correct. I mean, we can only quantify information that we receive. We have an open comment period, and FCMs and DCOs are welcome to give us as much information as they want to help us make these decisions. If they don't provide us with quantifiable information, we simply can't quantify it.
And that was, when you say that they don't provide it, that was in the request for comments, right?
That's correct.
The fact that we don't know what's being held in these funds today is also problematic, I would think. I do think. It's not a question, it's an answer. That's my own answer.
Yeah,
So.
I'm going to associate myself with what you just said about, I think we would be better served as regulators, and I think customers themselves would be better served if they knew how their FCMs were investing their money.
Agreed. That's all I have.
Thank you, Commissioner Malia. Commissioner Weejan.
Thank you. My questions have been more or less addressed already, but I did want to go over one point. Commissioner Summers raised it in her opening statement, I think in her question too, and Commissioner O'Malley just touched on it. But the goal of this rule, as I understand it, is to protect customer funds insofar as they're used as investments by the FCM or the DCO.
Correct.
But we do recognize, do we not, in this rule that there are a variety of different services that FCMs provide for their customers that would continue to be permitted notwithstanding this rule, correct?
Correct.
Don't want to put you on the spot too much, but I wonder if maybe you could give an example of that. You've actually probably provided a couple already here this morning, but actually take it back. Let me ask you this question. If a customer has provided Treasury securities to the FCM, and let's say those bonds reach maturity, and so at that point effectively convert into cash.
Yes.
But they want to reinvest the cash, or roll it over rather, into more Treasury debt. Would the FCM be able to do that transaction on their behalf?
Yes, that's an investment of customer funds. If, under your hypothetical, in the first instance, there was excess. This is not money that's required to be put out in a DCO or another FCM. This is just money sitting with the FCM. And let's say, either because the customer says buy some treasuries, or the FCM decides to buy some treasuries, they buy some treasuries, and then it matures, U.S. Treasury Department gives you cash back, the FCM's free to reinvest the proceeds in treasuries.
And there's nothing in this rule that would keep the FCM from buying those treasuries from an affiliated treasury desk if it's a duly registered entity. Correct?
No, it's an outright purchase. No?
Right. That's all I have.
Thank you, Commissioner Weechin. There not being any further questions, I'd like to thank the presenters as well as the rest of the team for the excellent presentation. And unless commissioners want to make any other further statements, I'd call Mr. Staywick to call the roll.
Commissioner Weegin?
Aye.
Commissioner Weegin, aye. Commissioner O'Malia?
Aye.
Commissioner O'Malia, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
As the A's have it unanimously, the staff recommendation is accepted and will be sent to the Federal Register. I guess somewhere I'll probably say something about technical corrections, but why don't I just do that now? If I could, what's that? Do it at the end? I can't do it now? All right, so seeking unanimous consent that whatever technical corrections staff needs to make in sending stuff to the Federal Register be allowed. Thank you so much, and then we're going to call up who's the next? Are we doing the next final? Or we're going to do the available for trade? All right. So this is one of these opportunities to seek further public comment on a proposed rulemaking that's already outstanding. We already have proposed rulemakings out on designated contract markets and swap execution facilities, and what we're considering is a staff recommendation to, in essence, open these up for further public comment, most specifically about the process that these swaps are, quote, made available for trading. And at this time, I'd like to welcome Bella Rosenberg, Amir, you're going to have to help me pronouncing your last name. What's that? Zaidi. I don't see Mauricio. So, and Rick Schultz, all of the Division of Market Oversights, to present their staff's recommendation to provide further notice of proposed rulemaking in the process of a designated contract market and swap execution facility to make a swap available for trading under Section 2H8 of the Commodities Exchange Act. I welcome Bella back because you were a team lead on another things, and this is what you do.
Thank
Bella.
you. Thanks. Amir is going to present.
All right, great, Amir.
Good morning, Mr. Chairman and Commissioners. Today, staff is recommending that the Commission approve for publication in the Federal Register a further notice of proposed rulemaking that would establish a process for a designated contract market or a swap execution facility to make a swap available to trade as set forth in Section 2H8 of the Commodity Exchange Act pursuant to Section 723 of the Dodd-Frank Act. Section 2H8 of the Commodity Exchange Act adds a trade execution requirement for swap transactions. This section requires that swap transactions, subject to the clearing requirement, be executed on a designated contract market or a swap execution facility. The exceptions to the trade execution requirement are if no designated contract market or swap execution facility makes a swap available to trade, or the swap transaction is subject to the clearing exception, that is, the end user exception. On December 22, 2010, the Commission published for comment in the Federal Register a notice of proposed rulemaking entitled Core Principles and Other Requirements for Designated Contract Markets, which did not address the available to trade provision. Additionally, on January 7, 2011, the Commission published for comment a notice of proposed rulemaking entitled Core Principles and Other Requirements for Swap Execution Facilities, which addressed the available to trade provision in a limited manner with respect to periodic evaluation and reporting. This further notice of proposed rulemaking is informed by public comment received in connection with the swap execution facility's proposed rulemaking. A key theme to emerge from those comments was that the Commission should establish a process for determining when a swap is made available to trade that includes greater Commission involvement. In light of the comments received and the fact that the designated contract market proposed rulemaking did not address the available to trade provision, this notice before you provides a process for both designated contract markets and swap execution facilities to make a swap available to trade within the meaning of the trade execution requirements. Under the proposed regulations, a designated contract market or swap execution facility would initially determine that a swap is available to trade for purposes of the trade execution requirement. To make a swap available to trade, a designated contract market or swap execution facility would consider, as appropriate, certain factors with respect to such swap, such as the frequency or size of transactions, trading volume, the number and types of market participants, or the bid-ask spread. A designated contract market or swap execution facility would be able to consider any one factor or several factors. Under the proposed regulations, a designated contract market or swap execution facility that decides to make a swap available to trade in accordance with the factors set forth in the regulations would submit to the Commission its determination either for approval or under certification procedures pursuant to the rule filing procedures under Part 40 of the Commission's regulations. Specifically, a designated contract market or swap execution facility would have to submit its determination either under approval procedures of Section 40.5 or under certification procedures under Section 40.6. Under the approval procedures, a designated contract market or swap execution facility would have to provide an explanation and analysis of the proposed rule and its compliance with applicable provisions of the Commodity Exchange Act and the Commission's regulations. The Commission would have a 45-day review period, which may be extended for an additional 45-day period in specified circumstances. Similar to the approval procedures under Section 40.5, if a designated contract market or swap execution facility chooses to submit its determination under the certification procedures of 40.6, it would have to provide an explanation and analysis of the proposed rule and a certification that the rule complies with the Commodity Exchange Act and the Commission's regulations. The Commission would have a 10-business-day review period, which may be stayed for an additional 90-day period in specified circumstances. Under the proposed regulations, upon a determination that a swap is available to trade, all other designated contract markets and swap execution facilities listing or offering for trading such swap and or any economically equivalent swap would have to make those swaps available to trade for purposes of the trade execution requirement. The proposed regulations would define the term economically equivalent swap as a swap that the designated contract market or swap execution facility determines to be economically equivalent with another swap after consideration of each swap's material pricing terms. Designated contract markets and swap execution facilities would also be required to perform an annual review and assessment of the swaps it has made available to trade and to provide electronically to the Commission a report of this review no later than 30 days after the designated contract market or swap execution facility's fiscal year end. This further notice of proposed rulemaking only solicits comments pertaining to the regulations proposed in this notice. At this time, I'd be happy to take any further questions.
The Chair will now entertain a motion to accept the staff recommendation to give further notice on these rules.
So moved.
Second.
I support the proposed rule to implement the process for determining a swap is made available to trade, or now I've learned, Commissioner Weegan tells me this is called MAT. Is that right?
That's what my staff tells me,
Oh, that's
Mr.
right.
Chair.
That's The Dodd-Frank Act requires that swaps subject to a clearing requirement be traded on a designated contract market or CEF unless no contract market or CEF makes the swap available to trade. Thus, this question as to, well, what does it mean for a CEF or DCM to make something, quote, available to trade? And I think, though we did not include this in the initial CEF proposals last December, that it's appropriate to seek further public comment and also to have a staff roundtable. I hope Bella and Amir are looking forward to that during the 60-day public comment period to really get the market input on this and to bring greater transparency to the process for making a swap available for trading. I just have maybe one or two questions, but anyone, is it correct that though Congress laid out in some significant detail a process for determining a clearing mandate, that Dodd-Frank did not have a similar set of statutory provisions in this regard?
Yes, that's correct.
So there's a real distinction as to what Congress did.
Yes, in the statute there is a distinction.
And I also just want to make sure you've asked a whole bunch of questions in this proposal, I mean, when I went through it, to get further input as well.
Yes.
Now, these 7 or 8 factors that were referred to by a couple of commissioners in their opening statement could be either a shorter list or a longer list in a final CEF rule. Is that right?
Yes, we also asked questions, as you mentioned, in the proposal about the factors.
Okay. Well, again, I'm going to support this proposal. I think it's good to get further input from market participants on this important matter. Commissioner Summers?
Thank you, Mr. Chairman. I have a number of different questions with regard to the proposal and a number of different concerns about the process. And I think I would start by saying that I think that there's potential for huge competitive advantages with regard to allowing DCMs and CEFs to make this determination. So just following up on the chairman's question, is there anything in Dodd-Frank that would prevent the commission from being able to make this determination instead of allowing the DCM or CEF? Could the commission be the one making the determination?
The Dodd-Frank Act doesn't specify who should make the determination.
I understand that it doesn't specify, but does it prevent us?
And it doesn't prevent.
Okay. So because I believe that the factors here allowing CEFs or DCMs to make these determinations on their own will bind the entire marketplace to the trade execution requirement, I'm wondering how we're going to do anything about it if a CEF or a DCM submits these under Part 40 as made available for trading. So under what circumstances would you anticipate that the Commission could find that a Part 40 submission reflecting a determination is inconsistent with the Act?
Well, under Part 40, as you mentioned, as all rules under Part 40, a DCM or CEF would submit their determination, and we would review an explanation and analysis that they would provide to us, and we would look at the factors that they used in their analysis to come up with a determination that something's made available to trade, and then we would have to look to see if that was inconsistent with either the Act or the regulations that we proposed.
And also the specific factors that were listed in the proposal were things that I think most people would consider would go to the determination about whether something is really tradable, and should be subject to the trade execution mandate. And I think the idea is too that as we get and look at the analysis, the description that the CEFs or DCMs supply with their filings, it's something that the staff and commission over time would gain more experience and maybe potentially come up with some sort of more formal commission process as you're suggesting, ultimately. And not, obviously that would be up to the commission at some time.
I think you have just completely identified where my concerns lie, because I believe that, and I guess have always assumed, that this would be a determination that the commission would make down the road after we gain experience and after we know what kind of factors should be considered. And my fear in allowing a DCM or a CEF to make the determination on their own is because of competitive reasons, we're going to have CEFs and DCMs that immediately want the determination to be made that all economically equivalent swaps have to be executed on a platform because they want that competitive advantage. And I wonder how we draw the line and what kind of factors we would consider would be inconsistent with the Act if a swap is only trading once a week or even once a day. Does that make a swap liquid enough to have the trade execution requirement?
Yeah, I just don't think we can make a judgment now. We'd have to look at the filings and the analysis that the CEF or DCM supplied and then evaluate it then as with respect to its compliance with the Act. But also, this is a proposal, so we'll be looking for comments as well as the roundtable that the chairman talked about to get more feedback on how we should approach this in connection with the final rule.
I would really encourage market participants to provide us with very distinct economic analysis with regard to a determination like this being made by individual execution platforms and what the disadvantages may be to other market participants. Thank you.
Thank you, Commissioner Summers. If I might mention, and it's sometimes there's role reversals here because I'm sort of probably inclined to being less prescriptive on this one than you are, or it appears that you may be. But I think part of what influences me is not only the statute, but our own commission experience on the SPIDIC determinations. When we, the commission, went through, based on the 2008 Farm Bill, to make these determinations, Commissioner Wiegand, you weren't here, but when we went through this on contract by contract to determine whether they were significant price discovery contracts, it took a lot of staff time. I mean, an enormous amount of staff time. It was, I think, a thoughtful and considered review, but it was a significant, now take that broader to the entire swaps marketplace, and when Congress didn't mandate that we do it, I mean, we'd be, in essence, putting ourselves in to a determination process even more than this process. I mean, this process has us involved. I mean, this process definitely has the Commission involved, but it sort of starts with the CEF or DCM and then has us review it through the Part 40 rather than possibly the other direction.
I understand that. I just would respectfully suggest that the SPIDIC determination did not carry with it significant competitive advantages.
Is your concern that one CEF might do it ahead of another one?
Absolutely.
So it may be
if you were determined to have a SPIDIC on your market, you had more requirements put upon that specific contract. It didn't give you an advantage that then market participants would be required to trade the SPIDIC on your platform.
So I'd like to continue this dialogue, but to better understand, because if it's about trying to make sure that one CEF is not ahead of another, it might be that still the determinations are made by the CEF, but somehow they get aligned, or it could be in terms of the effective date to give others time to catch up.
Also, just one point to consider on that. The swap transaction compliance and implementation proposed rulemaking proposed at least a 30-day time period before the trade execution requirement would kick in. So that would maybe address some of the concerns about one CEF getting a competitive advantage over another one.
Yes, though I think what Commissioner Summers and I were talking about is whether that would be enough, basically. Commissioner Chilton?
I don't have any questions. I want to thank the team for your hard work on this, and I do share some of Commissioner Summers' concerns. That's why we had the comment period, and as we learned from the last rule, it's important for us to get information from people, and it's hard for us to make, we're not the experts, and it's hard for us to make final determinations without fulsome input. So I encourage people to comment, come in and visit with us, and explain your perspective. But no questions, Mr. Chairman.
Thank you, Commissioner Chilton. Commissioner Malia?
I guess I'd first like to make sure that I'm operating on the same document. Is this a 30-day or a 60-day comment? Mr. Chairman, you mentioned 60 days in your remarks. I have a document that says 30-day comment period.
You probably have the right document. I don't know if I
We
said
propose 30 days.
I think, do holidays count? Because this is,
So the document is 30 days. We propose 30-day.
it should be 60 days, I think, consistent with what the President's transparency in government executive order would be.
Yeah, when are you going to do your staff roundtable? You're talking about.
Yeah, and that's another. I mean, you've obviously made. You've
Macy, you know, I'm channeling Macy.
I think a 60-day would be appropriate for this, and I'd make a motion that we do adjust it to 60 days.
I'll second the motion.
All right. Thank you.
Thank you.
No, I think I seconded a motion. It's just an amendment to it, so it still has to, probably Dave Staywick probably has to do something or not. Can I just do that by unanimous consent?
You can do it by unanimous consent, yes.
So I'll seek unanimous consent on that.
Thank you very much, Mr. Chairman. Obviously, we received a number of comments in the CEF proposal that put this on our radar screen, and a number of people have really raised significant concerns. And I would point out that some of the comments from the buy side on this were very concerned about an immediate decision, and I think to Commissioner Summers' points that they would there's almost a race to the bottom in their view of people listing products, regardless if they meet any of the 8, what do we have, 8 tests? 1 or 8 tests, that there's no disincentive for a CEF to list any product whatsoever and try to capture that liquidity right out of the box. And Rick, you mentioned that we would gain experience. I'm a little concerned that they would all list these products and there would be, that work would be done, and what experience we have would kind of already be behind us, and we wouldn't have an opportunity to really gain a lot of experience because every CEF would list every product. I don't see what disincentive they would have not to list a product, to possibly capture that liquidity, which I think was the concern of the buy-side comments. Why did we ignore the buy-side comments on these?
Well, first off, just the listing of a swap on a CEF or DCM wouldn't trigger the requirement. They would have to then file something with us under Part 40 and then explain, looking at the factors we enumerated or something else they felt was relevant, explain to us why they thought it should be subject to the made available to trade, the trade execution mandate, and that is something that, staff, the commission, we would look at in whether to allow that, either to approve the proposal or whether to allow it to go through as a certification. And that's what I meant, as we get those filings and look at their analyses, that we would, ultimately come up with, more specific criteria possibly, or, at least staff would have criteria and things that we'd be looking at in making these, in doing the reviews of the filings.
Do you envision please?
No, but it just wouldn't be the listing in and of itself would trigger that.
I understand that. So let's go back to the concerns of the buy side. They had asked for a more formal analysis by the commission to look at liquidity factors and a number of things, and to take some comment there. We didn't request that, or we didn't include that in the rule. What have we learned about pre-existing swaps? did we do any data analysis in development of these 8 factors or any other?
No, we didn't do any data analysis. As I said, I think these are the types of things that that most industry observers would consider when you're thinking about whether a particular swap might be liquid or tradable on a particular exchange. And again, we put those out as a proposal, and we're looking for further comment on whether there's other factors or how we should be treating them or narrowing them or whatever. And then, look at that in the context of developing a final rule.
I also would like to clarify that we took the factors that are listed in the proposal are from the comment letters. So these are the commenters suggesting to include these factors in making a determination whether something is available to trade. And I also would like to point out, even though I acknowledge there is a flexibility in the determination process, but made available to trade determination, because it's viewed as a rule, is going to be treated like any other rule that's submitted to the Commission for either certification or approval. So there is Commission involvement, there is some sort of Commission involvement in the process, especially if people are going to start submitting this rules under Commission's approval. We have the Commission, staff looks at explanation analysis, staff looks at the factors, so I would say there is some Commission involvement, significant involvement in the process. It's not ideal, but it's the step in the right direction.
What would happen if 2 competing CEFs offered the same product, send it up, we have, they're economically equivalent. They come up with different criteria for eligibility. How do we sort that out between the two products that are of identical nature? Do we pick a winner or a loser? I guess at the end of the day, we would say whatever criteria somebody selected.
I think the staff would look at the 2 filings and the analyses that were presented, and there would be one determination made by staff in connection with the 2 filings. And if it's that we agreed with either both or one or the other or presumably it'd be both, that the swap should be, that the filing should go through, then that swap would be made available to trade. Well, both swaps would then be subject to the trade execution mandate. I think part of the goal of having, staff looking at this is you wouldn't end up with circumstances where you would have differences, the same swap, maybe, one staff would make a determination that it, or not choose to file it, thinking that it's not subject to the execution requirement, where another one would. But if you had something come in, then the staff would be looking at this, and I think one goal is that you would have a consistent approach or consistent treatment for the same swap.
So once something's made available to trade and a CEF submits something, it's approved. It's a little vague on what economically fungible or economically equivalent is. So what if we have a buy-side participant looking to do a bilateral deal? Is it their obligation to go and search out the different rule submission or the self-certification and rule approvals that we have done to determine how equivalent their bilateral swap is, to determine whether they have to transact on screen or not? How is this all going to be coordinated to ensure that market participants aren't put in any jeopardy for trying to determine whether their product is economically equivalent?
Yeah, currently the rule submissions, any rule submissions are put on our website, and DCMs and CEFs, when submitting a rule submission, they would have to put those on their website as well. So if a market participant is doing an economically equivalent swap, and that has also been made available to trade, then they would have to currently look at our website to see if those swaps would also be subject to the trade execution requirement. We also do ask questions in the proposal about how market participants would know that an economically equivalent swap is available to trade, and also if DCMs and CEFs should also have to submit something for economically equivalent swaps.
So we're going to be the clearinghouse for all, at a minimum, they have to look at the Commission website to determine those that are economically equivalent, to determine that.
Yes, I just want to add one more point that we mentioned in the preamble that we're considering creating, maybe the Commission would consider creating a one-page on the Commission's website with all the submissions. At least it would be easy for the participants to see, and with a definition of what's economically equivalent is once the Commission goes final, and it will be easily accessible to the participants.
Well, this is complicated. The factors are complicated and somewhat vague, and I don't, that's why we have a comment period. So I appreciate the fact that we will do a comment period. We will extend the comment period longer than 30 days. We will have a roundtable because this is difficult. I don't know how we're going to weigh individuals. I think Commissioner Summers is right. We may be putting the wrong people in making this determination. Let me ask one other question, I guess. The link between clearing and trading. If we make a determination on the clearing, can we also make at the same time a trading determination? Would that one-stop shopping offer the market a little better solution, or at least less confusion?
Well, the clearing determination is a separate determination. The clearing determination looks at DCOs submit clearing determinations, and here DCMs and CEFs are the ones submitting made available to trade determinations. And also for clearing, there are other factors besides liquidity that go towards swaps that are required to be cleared. So those wouldn't be necessarily relevant to this process.
But we have 8 factors, aren't those? Don't we have some overlap in those 2 features? I mean, would it make them easier on the market to submit this once for a single contract?
Some of the factors here do kind of go to the liquidity factors of the clearing determination, but in that rulemaking, from what I understand, that's not really flushed out of what liquidity is. So we're not sure if that would be made at the same time, or if what those requirements are there.
But I think if you're talking about internally, I mean, staff would work together, so if there's an analysis done by, with respect to making a determination where a particular swap should be subject to the clearing mandate, then obviously we'll share that information from staff internally in looking at a filing with respect to a made available to trade. But I think on your other point is that, as Amir said, with respect to the clearing mandate, you're going to get filings from DCOs, although the Commission could independently do that, whereas the determinations, at least initially, with respect to the trading mandate, go to the exchanges, the CEFs and DCMs. So but I think internally we could certainly share, look at the same information, and it wouldn't be duplicating the analysis.
Well, that's encouraging. It would ideally, we'll have to look at the factors, and I think with these 2 roundtables that we'll be able to have absolutely the opportunity to ask those questions about can we and should we make single determinations. It would obviously save on our resources not to if we're already making one call and maybe working together, and maybe market participants need to think about how these things will interact. That could just save them some time and provide them some certainty going forward. Well, I think the comment period, hopefully everybody will comment. Now they'll have a little more opportunity to comment. They won't have to work through the Christmas holiday to get them in 30 days, so that's better. Thank you.
Before I turn to Commissioner Wiegand, there is a question on page 22, and Dan, I might want to make sure that you're focused on this as well. But is the Commission's proposed definition of economically equivalent swap appropriate? If not, how should it be, definition be changed, and why, and what other factors should consider when defining economic equivalent, et cetera, et cetera. My question for you, Dan, is if in a final rule in this matter we were to say, based upon commenters, these are the 3 things that define what economically equivalent is, that we can go final, that we don't have a administrative law problem, that we didn't ask enough questions. Because I, for one, would have been fine even if this proposal had economically equivalent means same tenor, meaning the same life, and the same underlying reference, just things like that. Now, maybe there's a 3rd or 4th thing, but I'm just using that as 2 examples, that it's the same tenor and same reference. because economic equivalent to me means really economically equivalent. But I just want to make sure we could. My question for you is an administrative law question.
The proposed.
We ask enough so that we could finalize with specificity about the definition of economically equivalent.
As long as there's notice in this proposed rule that this is the subject that the Commission is considering, and the proposed definition is something the Commission's considering. So as long as the final is a logical outgrowth of the proposed, there's adequate notice.
So this is adequate notice on, for instance, if economically equivalent were to be the same tenor and the same underlying, or might we need to add a question to help on that?
Well, that sounds like that could be a logical outgrowth, what you had just described.
Right.
But
if
the more specific
fellow commissioners would allow
questions.
me to add a question there. Is that right? So could you, Amir, make sure, like, for instance, that it would be the same tenor and the same underlying? What other factors could people,
That would be beneficial in providing the needed notice.
Commissioner Weejan. I'm sorry to have interrupted, but I was trying to build on what you were saying. Commissioner Weejan.
Thanks, Mr. Chairman. Thanks to the staff for all your hard work on this rule, and also appreciated the briefings that you provide on this. Listening to the questions this morning and reflecting on our briefings and conversations about it over the last couple of weeks, I mean, it seems like there is this real issue or question about whether and to what degree the Commission should be involved in these determinations. I think that's the main takeaway for me anyway after having these discussions. But I think one thing that would be helpful for me, and maybe for the public too, in helping assess whether or not what has been proposed here would do the trick and would reflect the appropriate level of involvement, is if you could, and it's been touched on a little bit already, but if you could walk me through again real briefly what the review process would look like in the proposed rule, and what exactly the Commission and the Commission staff would do under that process, which is under Part 40, as I understand it.
Sure. Under Part 40, like we mentioned, that a DCM or CEF would submit the available to trade determination, and then staff would look at that explanation and analysis that they give, that they provide with the rule submission. Would also look at how they consider the factors under the regulations, and then staff would either under the approval process or the certification process have 45 or 10 days to review. It could also be extended for an additional review period based on certain specified circumstances, like if it was a novel or a complex issue. And then if...
Sorry to interrupt, but if the staff or the Commission does nothing, then after, 10 days of doing nothing, that's when the rule becomes effective, is that right?
Right, that's correct.
I'm sorry, I didn't mean to interrupt.
Yes, so it would become effective. Otherwise, if staff would give notification that it's disapproving the rule, then it would provide a notification to the DCM or CEF that it's disapproving or it's objecting to the certification.
Do we have any sense at all right now how many products there are out there, potentially out there, that the Commission would act on?
I don't think so, not at this time.
Yeah, there's thousands of swaps that are out there, but how many would be filed under the trade execution mandate that made available to trade under this proposal? I'm not sure I could hazard a good educated guess.
Yeah, Commissioner Weejan, you could go towards, like, in clearing, LCH, the largest clearinghouse for interest rate swaps right now, is somewhere between 750,000 and 1 million individual contracts. That's not to say that those are each subject to trading, and in fact, if you enter into an interest rate swap on a Monday and then enter into a Tuesday, that's a different contract. So that gives you the widest scope. But how many contracts are on the futures markets right now to give you an order of magnitude there?
I don't. It's around 1,200, 1,400, somewhere in that range of listed products. But
so it's likely to be well in excess of the futures, but not all the individual dates and contracts of that bigger number.
I mean, I guess it might be fair to point if there are in fact that many products out there, and given the strains on resources, I guess you can kind of see where I'm going. I'm just trying to figure out, what the quality of commission involvement would be under this review process if there's so many contracts. So I'm just looking forward to the comments to see what folks have to say about that.
And I'd imagine, but just make sure, we do ask, people could make these submissions by class or group, similar to how they do it on the clearing side, or is that not the case?
That's not the case. We didn't propose that.
But wouldn't it be wise of us to, if it's somebody's doing, for instance, 2 to 3 year interest rate swaps, that they don't have to make 365 individual submissions. It could be one submission for 2 to 3 year interest rate swaps. Noting 365 calendar days in the year.
Yeah, a DCM or CEF could submit determinations under one rule submission. They wouldn't have to submit 365 rule submissions at one time. They could include the analysis for the different swaps that they want to make available to trade in one rule submission.
But could they do the analysis based on a class rather than that having a document for each? It would seem like burdensome on a CEF if they had to make 365 in my little hypothetical submissions, even if it was all appended to one document.
I guess I'm not really sure what makes the most sense. I think for clearing, that doing it by class, because you do, like LCH, you can clear thousands of different individual swaps, of interest rate swaps. I don't know if the same analysis or review would, for looking for the trading mandate, what's tradable would apply necessarily, whether you can do a kind of a broad review of a number, like you said, at the 3 to 5 year, that every one, the 3 year, 17 day, and whatever, they would all be subject to the trading mandate, that the same analysis would apply. I don't really know the answer to that. I think you can do that for clearing, but I don't know if that's would work for the trading mandate. It's just not something I've really thought about, but it might be something we can include as a question.
If other commissioners felt the same way, so that we could hear from the market participants, if we could add some question on that, but I don't know. Yeah. But it was Mark. We'll call it the Mark Weegin question.
Yeah.
Thanks. I think. I don't have any further questions. The only other thing I would say is that my impression is that Commissioner O'Malley has an especially keen interest in this, and so I'm looking forward to the opportunity of working with him on these roundtables so I can learn more from the market participants as well. Thanks.
I thank you, and Mr. Staywick.
Commissioner Weegin?
Aye.
Commissioner Weegin, aye. Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton? Aye. Commissioner Chilton, aye. Commissioner Summers?
No.
Commissioner Summers, no. Mr. Chairman.
I'm going to say aye, but before you summarize, that was with that question having been added. Okay.
The staff proposal as amended.
Yeah.
Mr. Chairman, on this question, the yeas are 4, the nays are 1.
I thank you, Mr. Staywick, and with the yeas having it, it will be sent off to the Federal Register as amended. Was there? No? So I think what we're doing next is some members of the Division of Market Oversight will be up to talk about the staff recommendation on final rule with regard to foreign boards of trade. Again, a particular shout out to two senators, Senators Feinstein and Levin, who worked so hard to help us, I think, move from a no-action regime to a more consistent registration regime. I'd like to welcome Dwayne Anderson, David, is David there? Yes, David Steinberg, Ryan Miller. Where's Ryan? I don't see him there. Oh, there's Ryan. David Van Wagner and Rick Schiltz, all of the Division of Market Oversight, to present the staff's recommendation concerning this final rule on registration of foreign boards of trade. I'll share with the public. Dwayne once said when we set up 30 separate rule teams, and this was one of them, Dwayne said he was just an island. He was off to his own, and he didn't think, well, actually, your, as you'll describe, has touched clearing, it's touched trading, it's touched just about every piece of what we do. So you have not been quite an island, Dwayne. But I'll hand it over to you. You want to hit the button so that we get the mic.
And it wasn't just me as an island, it was the team was an island. I'm here to present for your consideration the proposed final rule for Foreign Board of Trade registration. As you know, the Dodd-Frank Act amended Section 4B of the Commodity Exchange Act to provide that the Commission may adopt rules and regulations requiring registration with the Commission of a Foreign Board of Trade that provides its members or other participants located in the United States with direct access to its electronic trading and order matching system. The Commission may also adopt rules and regulations prescribing procedures and requirements applicable to such registration. For purposes of this registration, the Dodd-Frank Act defines direct access to mean an explicit grant of authority by a Foreign Board of Trade to an identified member or other participant located in the United States to enter trades directly into the trade matching engine of the Foreign Board of Trade. Of course, the Commission determined to establish a registration provision and published a proposed rule in November of last year. After reviewing the comments submitted in response to the proposed rule, we are proposing that the Commission adopt this final Foreign Board of Trade registration rule substantially as originally proposed, with certain modifications. The registration provisions will replace the current procedure in place since 1996 of staff issuing no-action relief letters to foreign boards of trade that wish to permit direct access. By adopting uniform application procedures and registration requirements and conditions, the process by which foreign boards of trade are permitted to provide direct access to their trading systems will become more standardized, more transparent to both registration applicants and the general public, and will promote fair and consistent treatment of all applicants. Generally applicable regulations will provide greater legal certainty for foreign boards of trade providing direct access. Commenters generally supported the adoption of a registration process. The process set forth in New Part 48 of the Commission's regulations. It provides that a Foreign Board of Trade must be registered in order to provide direct access and identifies standards that must be met to be registered and conditions that must be satisfied to maintain registration. Many of these requirements and conditions of registration have evolved from requirements and conditions that Commission staff currently applies to foreign boards of trade in the no-action relief letters. For instance, in determining whether to register a Foreign Board of Trade, the Commission will evaluate whether the Foreign Board of Trade's home regulatory authority oversees the Foreign Board of Trade in a manner that is comparable to the CFTC's oversight of DCMs. The operative word here is comparable, is used in both the registration rule and the Foreign Board of Trade provisions of the Dodd-Frank Act itself. Comparable is not interpreted to mean that the Foreign Board of Trade and its clearing organization have to be subject to oversight that is identical to the manner in which the CFTC oversees DCMs and clearing organizations. Instead, the rule provides that the comparability determination will be based on a principles-based review in which the Commission will look to determine if the Foreign Board of Trade and the clearing organization's regulators support and enforce regulatory objectives in the oversight of the Foreign Board of Trade and clearing organization that are substantially equivalent to the regulatory objectives supported and enforced by the Commission in its oversight of DCMs and DCOs. These objectives would include such requirements as prevention of market manipulation and customer and market abuse. Part 48 describes how and where to apply for registration and provides a limited registration application process for those foreign boards of trade that currently are operating on staff-issued no-action relief letters. Many of those who are recipients of the no-action letter commented to the proposed rules. In response to their comments, the Commission has attempted to make it easier for those who are operating under a no-action letter to register. That is, originally they had to make a limited application within 120 days from the effective date of the rule. That's been modified out to 180 days. So they now have the 2 months the rule takes to become effective, and then 180 days after that in which to submit a limited application. During that period, they can continue to operate pursuant to the no-action relief. If they get their application in at the 180-day point, they can continue to operate pursuant to the no-action relief until such time as the Commission acts upon their application, that is, by issuing an order of registration or a notice of action indicating that the Commission will not register the Foreign Board of Trade, at which time the no-action letter will be withdrawn. Part 48 describes the requirements that foreign boards of trade would have to demonstrate they meet in order to be registered. Whether they're successfully met will be determined by a review of the information submitted by the applicant in the application forms, and, as necessary, a staff on-site visit to the Foreign Board of Trade, the clearing organization, and its regulator. With respect to the clearing and settlement requirement, Part 48 requires that the clearing organization either be registered with the CFTC as a DCO or demonstrate that it observes generally recognized international standards, the RCCP's recommendations for central counterparties, or successor standards. In response to comments, the Commission has modified the final rule to reflect that if a clearing organization is registered with the Commission as a DCO, we would need no further information from that clearing organization as part of the Foreign Board of Trade's registration process. Part 48 also details the conditions that a registered Foreign Board of Trade must meet to retain its registration, including general conditions, reporting obligations, and conditions that apply to linked contracts. Staff believes that most of the general conditions and reporting obligations, including quarterly volume reports, are being met by foreign boards of trade currently operating pursuant to direct access no-action relief. The linked contract conditions include those identified in the Dodd-Frank Act and those derived from Commission staff experience in issuing no-action letters, and currently are being met by the one Foreign Board of Trade that is operating pursuant to direct access no-action relief that lists linked contracts. Part 48 identifies the types of entities to which a registered FBOT could grant direct access. That would include identified members and other participants that trade for their proprietary accounts, FCMs that can submit orders on behalf of U.S. customers, and CPOs or CTAs, or entities exempt from such registration that submit orders on behalf of U.S. pools or for accounts of U.S. customers for which they have discretionary authority. Again, this list of eligible participants is consistent with the participants under the existing no-action relief. With respect to new contracts that are not included in the original application, Part 48 describes the procedures to be followed by a registered Foreign Board of Trade that wants to make them available, including non-narrow-based stock index futures contracts. Part 48 also identifies reasons for which a Foreign Board of Trade's registration could be revoked, including failure to satisfy registration requirements or conditions. Finally, the appendix to Part 48 has been modified from a list of items that are required in the original proposed notice to application forms that include the same requirement for information. I'd like to thank my fellow team members for their exceptional efforts in creating this proposal, and that includes David Steinberg, my deputy team leader, Ryan Miller, Philip Colling, and William Maldonado from DMO, Carlene Kim and Neil Kumar from OGC, Jocelyn Partridge from DCR, Michael Pennick from OCE, Peter Cowles from DSIO, and last but not least, Robert Rosenfeld from OIA. I'll be happy to answer any questions that you may have.
Thank you, Dwayne. The chair will entertain a motion to accept staff recommendation and consider this final rule.
So moved.
All right. I support the final rule to implement this Foreign Board of Trade registration regime. I think it's very appropriate that we have a consistent registration regime. We didn't have this opportunity before Dodd-Frank. We, as Dwayne went through, used something called no-action letters. And I know that sometimes it was a little bit concerning to members of Congress why we didn't register these entities, and now we have a specific registration in our statute. I just really had one question. It's for somebody not at the table, but it's for Jackie Mesa, who's the head of our international. Jackie comes to the table. But Jackie, I just want to understand how foreign jurisdictions see this, because I know we've shared as we've been going through these, dozen or 15 months, and we always want to coordinate closely. I know Jackie and I are flying out tomorrow night to Paris to be at these meetings on Wednesday and Thursday.
As you rightly point out, foreign regulators and foreign exchanges have been very interested in this rule and this provision in Dodd-Frank. They've really benefited from our recognition procedures in the past, and we're curious on how we would be changing it. And so we have been talking about it in international meetings where foreign regulators and exchanges attend, but also in our bilateral discussions, it always comes up on how we're going to proceed in this area. And I can tell you that largely the biggest concern was whether we were going to back away from a recognition regime and a comparability analysis, and whether we were going to require it like a domestic exchange, full registration. And I think as the rule reflects, we are going to maintain our recognition for foreign exchanges and a comparability analysis, and that was their biggest concern. So we haven't had any other specific concerns from foreign regulators, and I think they seem relatively comfortable with the rule we're proposing today.
Great. I thank you, and that gives me additional comfort. Commissioner Summers.
Thank you, Mr. Chairman. I'll continue on this same path of questioning to just clarify that this rule creates a registration system, not a dual registration for these foreign boards of trade. They will not be duly regulated by us and their home country regulator.
That's correct. That's what this rule does. Dodd-Frank provides that we look to the foreign regulator for comparable, comprehensive supervision in the home country. The foreign regulator is the primary regulator. They are registered with us just for the purpose of providing direct access.
Thank you. I have a couple of questions on the process, and with regard to the process for limited registration in those foreign boards of trade that are already operating under no action relief. And you said that they will be able to continue to operate until the Commission acts. So there isn't a deadline that would kick in that we have only a certain amount of time to either approve or disapprove their registration status.
We have no time criteria on ourselves. Now, we have established the 180-day time period for the application, but we have amended the rule to say that it is required to be in good faith on the part of the applicant, a complete application. And we can work on that application, and if down the road it turns out to be materially incomplete, we can work with the Foreign Board of Trade to get it complete.
And if a foreign board of trade that is currently operating under no action relief does not have an application, even in good faith, within those 180 days, do we immediately revoke their status?
That's unclear. I don't anticipate that happening because we're telling the foreign boards of trade, we're encouraging them to come in draft form before the 180 days. We're working with them to get a document that looks good when they do come in. I will be in contact with all of them, and they will certainly be pressured to have something here at the 180-day point.
Okay.
The ones that have the no action letters, the ones that might not have anything are probably the ones that will no longer have business from the U.S. But the other will certainly have something here because they want to continue to operate with business from the U.S.
I believe that the way that this rule is written, it also captures those people who currently have pending applications for no action relief to be part of the limited registration. Is that correct? And how many of those do we have pending right now?
We have 7 people who have submitted applications, but I don't know they're all going to be considered valid applications. One of them, for instance, is a European MTEF, a multilateral trading facility, and we have not addressed the issue of whether an MTEF is subject to comparable comprehensive supervision and regulation. that the Commission applies to DCM. So I'm not sure whether that's going to turn out to be a valid application or not. We'll have to spend some time with that one.
Because those people who have pending applications for no action relief are not able to actually operate during this time frame while we're considering applications, will they be first in the queue?
If they wish to be. I mean, there's no incentive for them to wait 180 days, certainly. I mean, we're allowing them to do the limited part of the application process that allows them to identify documentation that they have already submitted to us and tell us that it's still current and valid and apply it to their new application. They can certainly begin application right after the effective date, and my understanding is at least 2 of those who have pending applications are going to be here probably day 1 after the effective date.
Right. I guess I would just expect that their applications would be the most current of anyone who's there.
Certainly, we will look at those as they come in, and they have more incentive to come in right after the effective date than the exchanges that are operating under no action relief.
Right. Thank you so much.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks again for all your work. I have a general question about comparability, and I appreciate the final rule in that it's using a principles-based look at our brethren regulatory regimes and the foreign boards of trade. But I have a specific question with regard to look-alike contracts. That is, contracts that are offered on a U.S. exchange, potentially for delivery in the United States. Is there any added criteria other than that principles-based general look at a foreign board of trade with regard to adhering to any of our rules or regulations? We all remember the ICE circumstance where ICE London has a look-alike to the WTI contract offered on NYMEX for delivery in the United States. I'm curious, does this address that sort of possibility?
There's a long series of conditions that apply in the ICE situation because that's a linked contract. It's actually, the price is linked to a contract traded on a registered entity. Those conditions are in the rule. We have also asked the foreign boards of trade to identify any other kinds of contracts which may have some relationship to a contract traded in the United States. For instance, MRX and NYMEX both traded freight rate contracts that use the same third-party price for settlement. Now, it turns out that there was no market manipulation issue there. There was no potential problem, but we needed to know about that. And if, in fact, we get a contract listed in which there is a potential problem, we've given ourselves the option of imposing additional conditions on that contract, all the way up to and including the same conditions that we impose on linked contracts.
Very good. That's helpful. And no other question, but for the people who don't understand why this is an important issue, if you have a contract on a U.S. exchange and there's a look-alike contract on a foreign exchange for delivery at the same place in the United States, what we've seen happen in the past is that traders would reach a level at which they feel like they're above what are currently accountability levels on the U.S. exchange. These aren't position limits, but they're accountability levels, sort of a loosey-goosey position limit, if you will. That then they would, in order to have greater exposure in that same contract, this crude oil contract, they'd go to the look-alike contract in London and have positions there. And they could do the same, well, when you combined all of those in aggregate, they could have a significant, what I would term excessive speculative role. So this rule allows us to look at those sorts of things and ensure that they are meeting more than just a principles-based test, but an actual test similar to what we did in the specific crude oil example with regard to WTI.
Yes, sir. And as a matter of fact, among the linked contract conditions is reporting in the COT position limits that are comparable or identical to the position limits at the registered entity on which the contract is based. And ICE Futures Europe has been complying with those for some time now and will continue to. And any additional linked contracts get listed by other foreign boards of trade that want direct access will also have to meet those conditions.
Thank you very much. Thank you again for your work, guys.
Thank you, Commissioner Chilton, Commissioner Amalia. Thank you to the team for working through this. In the rule, proposed rule, we have the term observance of recommendations for central counterparties. Now, Dwayne, you'd mentioned comparable regulation, but in this we use the term observance of recommendations for the central counterparty. How will the Commission evaluate a clearing organization's, quote, observance of recommendations of clearing counterparties? I see Mr. Wasserman is in the House.
We're going to defer the questions on clearing to the clearing expert.
Thank you, Commissioner Amalia. As you know, the currently applicable standard internationally is the recommendations for central counterparties. The Committee on Payment and Settlement Systems and IOSCO have a team, or a number of teams actually, working on updating these recommendations to what are going to be the principles for financial market infrastructures, and I'm actually participating in that effort. There is a intention that those will be completed by the end of March and applicable by the end of 2012. Along with those principles, we are developing, with the help of the World Bank and the IMF, an assessment methodology to determine observance of those principles, both at the principle level as well as certain key considerations. That, I think the intention of this rule is to permit, so long as the recommendations for central counterparties are effective, one may essentially demonstrate observance of those. On the other hand, as may likely happen given the time schedule, in the case that the principles for FMIs have been finalized but are not yet effective, an entity would be able to, if they so chose, say, well, let's just skip over and go directly to the PFMIs and demonstrate how those are observed. As I mentioned, there is an assessment methodology, and essentially what that looks is that is still in development. It has not yet been finalized, but essentially, as with a number of international standards, it looks at whether the standards are observed, broadly observed, partially observed, and it strikes me that the approach we will be taking is going to be a flexible one, because essentially it may well be the case that perfection is very, very hard to achieve in terms of observance of each and every key consideration of each and every principle. And so, obviously, if in some cases, if the standard may be broadly observed rather than observed, that would not, it seems to me, be disqualifying. Obviously, when one gets down to partially observed and not observed, that might be somewhat of a different story. But I think the key point is it needs to be done in a bit of a more flexible and thoughtful manner rather than, okay, this box was not checked, you're out.
This is a key point. This was the first question I was asked every time I went into a meeting with foreign regulators in my recent trip to Asia, so that they were keenly aware of the IOSCO principles, Bank of International Settlements. They do support a principles-based. What happens if there's a difference between our DCO core principles and the international principles-based standards? They were concerned that they would be tugged in two different directions, on a clearinghouse at least. And now that we've linked clearing and trading in this regard, they were uncertain how that might play out.
As I read it, they have two choices. They may register as a DCO, and if you have a registered DCO, that's the end of it. Now, obviously, we are supervising those DCOs, and if we have some concern with what the DCO is doing, then DCR, as part of its supervisory activities, would be addressing that, but that would not be part of this exercise. So under this exercise, if you're a DCO, you're in. Alternatively...
In meaning under our DCO core principles.
Yes. That is to say, if you are registered as a DCO, then for purposes of this rule, that is enough. One just simply says, I'm registered, and we review and say, yes, indeed, you are, and that's it for these purposes. Alternatively, If you are not registered as a DCO, then what you must do is observe this international standard, the RCCPs, or in the fullness of time, the principles for FMIs. And so then the question is not, do you meet the core principles for DCOs? If you're not seeking registration as a DCO, you would not be measured against those principles. You would be measured against, I'll just use the principles for FMIs and your observance of those.
Thank you very much. Do other jurisdictions utilize or rely on an FBOT-like registration regime so their citizens can directly access U.S. exchange? And if so, do they require the same standards that Mr. Wasserman here just laid out?
Foreign countries do have standards for instance, CME or NYMEX to make a system available from their country. And I'd like to ask Jackie to come back up here and talk about similarities or differences.
We have a musical chair on the end here. Yes, they do have a similar process in foreign jurisdictions, and we looked at this pretty intensely a couple of years ago, pretty thorough analysis, and most apply the same standards across the board because there were principles developed in IOSCO for recognition of direct access. And so everyone bases their regimes off those IOSCO standards, and we did the same here.
So it's a two-way comparability street here. Okay.
That's right.
Thank you, Jackie. Can you walk me through the real-time reporting obligations for swaps under the FBOT rules?
The real-time reporting is, I believe, going parallel to what we're going to do with DCMs, and that is the swap data will be provided to an SDR once there are SDRs available, and the SDR will do the real-time reporting.
So an FBOT would report to U.S. SDRs or their respective?
It's either one that's approved by the Commission or has an information sharing arrangement with the Commission. That's our standard for SDRs.
So an entity in a foreign jurisdiction has to report to a U.S. SDR under the FBOT rules?
Yes.
One last question on pending contracts. Obviously there are contracts for clearing and trading that have been submitted and will be submitted, I suspect, under the no action relief. How will we treat contracts being reviewed under that separate process while we're doing the FBOT? Are we going to wait until we complete the FBOT before we go back, or can we walk and chew gum at the same time?
I think we'll continue to look at contracts submitted by FBOTs under the no action provision. The difference is that the no action provision does not provide for swaps contracts. So in all likelihood, they will have to hold off if they want to trade swaps until they're registered, which would be an incentive for them to register as well. But we're reviewing contracts even now from Foreign Boards of Trade operating under the no action letters.
Well, assuming they're able to get their registration in on time, would they then be able to submit contracts if they submit within the 180-day period? Would they then be able to submit swaps for trading?
Once they're registered.
Once we determine their
once we
finalize. So it's really it may be an incentive for them, but we're really the gatekeepers as to whether and they get to move these contracts, and it's up to our pace to determine when that final rule is approved, correct?
Yes.
All right. So regardless, they have 180 days, but they have to still wait for us to finalize.
If they're really interested in trading swaps, they can submit the application the day after the effective date of the rule if they wish. I mean, Foreign Boards of Trade under the no action relief have always been treated as parallel to DCMs, and DCMs have never been able to list swaps, so they've never been listed under the Foreign Board of Trade no action relief. So it's new on both ends. It's new on the DCMs and it's new on the Foreign Board of Trade.
But you could probably understand their concern when they say you demanded 180 days, and yet I have no certainty going forward as to when you will approve my contract.
Oh, that's true.
Or your exchange.
That's true.
I suspect we have some concerns in that area. Thank you very much.
Thank you, Commissioner Matty. Commissioner Weejan.
Just want to start by thanking the team. I appreciated the briefing that we had on this rule a couple of weeks ago, and appreciate everyone's hard work in getting this rule finalized. I don't have any other questions. I just wanted to, I guess, restate something I alluded to in the opening statement, which was, I think on balance, it's better to have a registration approach or a registration regime as opposed to a no action letter regime. I think there are a lot of benefits to that for market participants that were covered in the preamble of the rule. So I'm happy to support the final rule today. Thanks for all your help.
Thank you, Commissioner Weegan. Thank you for everybody on the staff. Mr. Staywick.
Commissioner Weegan.
Aye.
Commissioner Weegan, aye. Commissioner O'Malia?
Aye.
Commissioner O'Malia, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you, Mr. Staywick. The ayes having it unanimously. The staff recommendation is accepted and will be sent to the Federal Register. I think, Mr. Staywick, I already did a unanimous consent on technical corrections. Is that right?
Yes. You were going to. You mentioned it. You might want to just restate it now.
I have. All right, I'll do it now. So at this point, I ask unanimous consent to allow staff to make technical corrections to documents voted on today prior to sending them to the Federal Register without objection. So ordered. Our next scheduled public meeting will be Tuesday, December 20th, and the subjects of the rulemaking presented in that meeting will be published on the Commission's website, as is our practice under the Government Sunshine Act, 7 days before the meeting. If there's, did you want to say something?
I did very briefly.
All right. I'm sorry, because I think I have a minute. I need to go to an FSOC meeting, but go.
Well, I'll be very quick. The chairman and I have spoken several times about the swaps definition, which the position limit rule is dependent upon the swaps definition. And I know you are working hard to push that. I know you were asked about it before the Agriculture Committee the other day, and it's a joint rule. It's mandated that it's a joint rule between the CFTC and the SEC. So as much as we might like to at times, we can't control everything. But I just reiterate that this is an important issue for me, that I know it's important for a lot of us, but that we got to get this thing done, and I appreciate the forbearance of the chairman as I continue to nip around trying to push us to do that.
I will say this. I think it's critical that we complete the further definition rules, the entity definition that related to swap dealers and securities-based swap dealers and so forth is further along. There's nearly a pens-down version that we can distribute to all of you, and you've all given some input on that comment summary over the last 2 months. We're frankly just not as far along on the products because it was proposed in April, whereas the entities one was proposed, I don't know, 5 or 6 months earlier. But I'll raise it with Chairman Shapiro again in about a half an hour when I'm at the FSOC.
Thank you, sir.
Thank you.
Mr. Chairman, to the point on the meeting on the 20th, obviously we're approaching the holidays, and the more specificity we can have and the staff can have about who will be up on the 20th and potentially January 5th as well, so we can marshal our forces and address the appropriate rules. And we want to be as responsive as possible, but we also need to protect the staff that has worked extraordinarily hard and protect their holidays to the extent that we can. And if we can narrow down those so we can address specifically the rules that we are going to be working over the holidays, I would greatly appreciate that, and cut everybody loose if they're not going to have to be ready for the 20th or the 5th.
I think that's very good, and glad to have feedback. I think there's 5 documents that are pens down version in each of your hands for finals. I think that's right. So those are the ones that are possibly, but I know that we're not going to do all 5 on December 20th. But I mean, to get some feedback from commissioners' offices as to which ones you think, whether it's 3 of them, 4 of them, which ones also people think. And in terms of January 5th, we'll continue to work on that because we still have a few days before the pens down version. Before that, it may just be that some of those 5 are split between December 20th and January 5th.
And I'm happy to work through that. I know we can't necessarily be 100%, but to the extent that the Commission can make a determination so we can tell everybody what their holiday future may be in store. Obviously, we're going to be working and reading through the rules, and we're going to have to, we just want to make sure we're asking the right staff on the right rule teams to participate and cut the rest loose if they don't have to be here.
Yeah, absolutely agreed. Absolutely. With that, I guess if there's no other further business, I'd entertain a motion to adjourn the meeting, right? That's what I'm supposed to do?
So
Will be
moved.
adjourned.
All in favor? Aye. Any opposed? Thank you very much.